out there.
Things picking up? Things picking up? In
Steady,
industry?
yeah, it's picking up. Yes, sir.
Refineries tell me they're starting to kick off more projects.
Yeah, lot of work out there.
And I tell you, the last 2 months, I mean, it's been a lot more people coming in with new projects.
Yeah.
Wherever. I-10, Highway 90, out by ExxonMobil.
Yep.
Polyethylene plant, several new prospects.
There's plenty of work for everybody. We thought we were gonna get that Howard Energy job.
Yeah, I
was mine.
chewed on Bart a little bit about that.
Did you?
Mhm.
Okay, we're ready.
Because I'm trying to think of who told me.
I think Echo picked it up.
I'm trying to think of who told me y'all were a little bitter.
I heard that.
No, it was somebody out of town, because I raised Cain about them hiring somebody out of town whenever
I
I had.
negotiated when we weren't able to.
All right, if y'all will raise your right hand. You and each of you solemnly swear or affirm the testimony you're about to give in this call shall be the truth, so help you God.
Yes.
All right, I'm gonna hold up what purports to be the last will and testament of Thomas Walter Humphrey. Do y'all recognize that as being his original will?
Yes.
I'm gonna go back to the signature page. Y'all, if that's his signature.
Yes.
And after the date that he made this will on June 27th of 2006, other than by the codicil, did he otherwise revoke or amend it?
No.
Okay. Now I'm going to show you, does that purport to be the first codicil to the last will and testament of Thomas Walter Humphrey?
Yes.
Also his signature on that document.
Yes.
And he never revoked this document after the date that he made it. Is that correct?
Right.
All right. And y'all been given a proof of death and other facts?
Yes.
And have y'all read that document?
Yes.
Everything in there true and correct and within your personal knowledge?
Yes.
Yes.
Okay, y'all go ahead and sign those just as your names are on there. I'm sorry to preempt you, Mr. Garcia, but it's easier since I have the documents here for me to do it.
Your Honor, I learned a long time ago, if everything's going right, don't interrupt the judge.
You have their oath? Did you prepare an oath? Did you file an oath for them, Mr. Garcia?
I believe an oath was filed, but I was speaking with Mr. Havard over the weekend, and he said he would get in touch with them later today to get it notarized. So my
Okay.
assumption is that'll happen later today.
Yeah, why don't we see if we have it?
Not, I can email it to the
When
court.
they're e-filed, it may be a delay when we come back on a Monday before the clerk's office gets it to us. If it's filed on Friday.
If it'll be helpful, I could email it to the court, however you want to do it, Your Honor.
She's going to take a look. Yeah, I had meetings, 2 chemical plants last week, potential chemical plants. One looking at buying a couple 100 acres on I-10, which is a
New one's moving in.
Is that
Mr. Garcia,
Yes, Your Honor.
these oaths need to be revised. It has it as an unsworn declaration rather than a notary. But can you provide us a revised one that has a notary seal?
Yes, I can. Would you like that via e-file or just directly email?
I'll tell you what, why don't you email them to Mr. Havard? He can get them to sign those before a notary in his office. He can then e-file those, and then they'll be able to get their letters.
Excellent.
Okay?
Right now.
All right, otherwise, we are good to go.
Thank you, Your Honor.
All right, well, I hope you have a great week.
You as well. Take care.
So
Thank you.
what happened?
Thank
You
you.
sign your proof of death and other facts. Once you sign I've got to sign the order. Yes.
This one for what?
Application. Uh, Today is the 5th.
Fourth,
Correct.
better fix that.
It's always been correct. Okay, so I've signed the order authorizing the county clerk to issue letters testamentary. The letters are what you're going to use to show that you have authority to act on behalf of the estate so that you can sign documents, make insurance claims, deal with stock transfer companies, whatever. But you won't be able to get those until they file the oath. As soon as he files the oath, you can get as many copies of those as you want. They're good for 90 days. And then if you need more past the 90-day period, you just come back and pick up more from the county clerk. And I know Mr. Garcia will take care of y'all, directing you with the rest of the stuff that needs to be done.
I guess we could have done this by Zoom, but I wanted to come here. I wanted to see-
Well, I'm
see the
glad you
process.
came here
Yeah.
before 2 years ago.
That's for this.
That's for that contested.
Oh, yeah, for this.
Oh, Brinkley's. Oh, I'm thinking
Yeah,
Don Ford.
yeah. I got you, girl. But now, I'm sorry, I'm like.
Oh, yeah, great. I didn't know the judge. My
That my friends. Oh,
on William.
I don't think it would be.
Okay, sweetie. Thank you. I'm in James Black first, is that fine? You're doing
Yeah.
Atkins
Oh,
first?
mhm, yeah.
Okay.
Hey, Ms. Perazzo, you are muted.
Good morning, Judge. How are you?
I'm doing well, thank you.
Hi, Mr. Black.
Good morning. How are you?
I'm doing well, thank you. How are you?
I'm fine, thank you.
All right, what has been done with respect to the attorney ad litem's suggestion that John Edward Atkins be listed as an heir?
So, Your Honor, I had filed a response to that, and I had also,
I didn't see that.
oh,
When did you file it, Ms. Perazzo?
this was like almost 2 months ago. Yeah, and I also had filed the statute. Give me just a minute, sorry. I figured since I hadn't heard from y'all about it, that it wasn't an issue. But essentially what it boils down to is that because he was adopted, that his rights to inherit dissipated, for lack of a better term.
That's normally not the rule in Texas unless it's specifically included within the order terminating the parent-child relationship, I believe. So I don't have your response.
Okay.
I've never seen it. They're gonna have to get it. I'll tell you what we're gonna do. We're gonna go ahead and take testimony,
Okay,
and then we'll clear up this issue so that we don't have to inconvenience the parties further.
I appreciate that, Judge.
Thank you.
Okay, so Tammy Franklin, where are you?
She is
All
right
righty.
here, Your Honor.
And Carolina Batista and Kevin Moore. All right, if y'all will raise your right hands, please. Do you and each of you solemnly swear or affirm the testimony you're about to give in this call shall be, and in, I should say, in cause numbers 124014, the estate of William Clifton Atkins, and cause number 124023, the estate of Mary Darlene Atkins, shall be the truth so help you God?
Yes.
Yes.
I heard 2 yeses.
Yes.
Yes.
Very good. All right, go right ahead, Ms. Perazzo.
Thank you, Your Honor. Ms. Franklin, would you state your full name for the record?
Tammy Christine Franklin.
And we are here today on the second amended application to determine heirship and second amended application for letters of independent administration and for the issuance of those independent letters of administration. Is that correct?
Yes.
And we're here today because you're asking the court to appoint you as the independent administratrix of the estate of, and that's your grandfather, William Clifton Atkins. Is that correct?
Yes.
And Your Honor, I would take notice, or I would ask the court to take judicial notice that the waivers and consents of all of the heirs are currently on file and have been on file for the requisite period of time.
So noted.
Thank you. Have you had an opportunity to review the proof of death and other facts along with the oath of independent administratrix?
Yes.
And is everything true and accurate in those documents?
Yes.
And I do understand that there is an issue of an heir that was born to William Clifton Atkins, and he was adopted.
She filed. It's not in
I'm sorry, so John Edward Atkins, let's talk about this for just a moment. Judge, did you want me to go ahead and get testimony concerning this?
Yes, let's hear what the facts are. Let's get that in evidence so that I won't have to come back and ask you any questions.
Yes, sir. So it's my understanding that William Clifton Atkins was the father of John Edward Atkins. Is that correct?
Correct.
And he was adopted in 1976. I believe it was April 22nd of 1976 by, and I'm sorry, what is the adoptive father's name?
Stephen Robert Castle, I believe.
Okay.
And I provided the adoption papers.
Yes, and I'm actually looking at that. And Your Honor, I'm looking at,
Okay, is Maxine Ann Rupert the same person as Maxine Luding?
yes, sir. That would also be the wife, the previous wife
the
of
mother of-
William Clifton Atkins, who was the mother
Yes.
of John Edward Atkins.
Yes.
Okay. And the person that adopted him was that her husband at the time?
Yes,
Okay.
Stephen.
And I'm sorry.
Stephen.
Yes. And looking at, and I don't know if you want me to, well,
My grandfather signed the document to give away his rights.
right. Your Honor, I would also take judicial note or ask the court to take judicial notice of the adoption judgment that is presently on file with the court as well. I don't know if you've had an opportunity to see that.
I have it here in front of me. So noted.
Okay.
It will be admitted.
Okay. And do you know where this adoption took place?
Me?
Yes, what state? Isn't it true that the adoption took place in Montana?
I believe so. I don't recall, but I can look at it real quick.
Well, according to the adoption judgment, that's.
Okay.
Okay,
If that's
does
where
that
it says
refresh it?
Montana, then yes.
Okay, so the adoption took place in Montana, to the best of your recollection?
Yes.
Okay. At this time, okay, I guess I'll save my arguments. I'm not sure how we want to do this, but I'm going to go ahead and pass the witness at this time to Mr. Black so he can ask his questions.
I don't have any questions, Your Honor, of the witnesses. I just have a comment in my report. I erroneously stated the adoption was taking place in Idaho, and it was Montana. I wanted to correct that. The decree I attached to my report, the decree of adoption is from the state of Montana. The divorce of the parties was in Idaho, and there is also attached a satisfaction of judgment as to support payments in conjunction with the adoption. That was in Idaho. I think that it's without question the adoption did occur in Montana.
Very good. Thank you, sir.
And Your Honor, so in my response, I would like to just point out that I sent a copy of the Montana Code annotated. It was in 2019, the last time it was updated. And under intestate succession, it's chapter 2 UPC.
Tell me what section you're looking at.
Okay, it's the Montana Code annotated of 2019. And it's Title 72, Chapter 2, Part 1, under intestate succession. And it discusses it's actually the section that applies is under the parent and child relationship. So it'll be 72 to 124. And
722,
yes, 72-2-124, parent and child relationship.
uh-huh,
And if I may read that section, it's not a very long section.
okay,
It says, except as provided in subsections 2 and 3, which are discussed in a minute, for the purposes of intestate succession by, through, or from a person, an individual is the child of the child's natural parents, regardless of their marital status. The parent and child relationship may be established under Title 4, Chapter 6, Part 1. Number 2, an adopted individual is the child of an adopting parent or parents and not of the natural parents. But adoption of a child by the spouse of either natural parent has no effect on, which this doesn't apply, the relationship between the child and that natural parent, or the right of the child or descendant of the child to inherit from or through the other natural parent. Inheritance from or through a child by either natural parent or the parent's kindred is precluded unless that natural parent has openly treated the child as the parents and has not refused to support the child. So essentially, this is saying that the child would not be the natural child of William Clifton Atkins for intestate purposes.
okay, I'll be happy to read that after the hearing, after I finish my other hearings.
Yes, sir. Okay, Your Honor, at this time, I'd like to call the witnesses. First, I would call Kevin Moore. And Kevin Moore, would you state your name?
Kevin Dwayne Moore.
And Mr. Moore, have you had an opportunity to read the affidavit of facts concerning the identity of the heirs for the estate of William Clifton Atkins?
Yes, ma'am.
And is everything true and accurate to the best of your knowledge?
Yes, ma'am.
Okay. And I pass the witness.
I have no questions, Your Honor.
Okay, go right ahead.
At this time, I would call Carolina Batista.
Yes,
And would you state your name?
Carolina Batista.
And have you had an opportunity to review the affidavit of facts concerning the identity of the heirs for the estate of William Clifton Atkins?
Yes, I have.
And is everything true and accurate to the best of your knowledge?
Yes, it is.
Okay, I pass the witness.
No questions, Your Honor.
And I have no further witnesses for the estate of William Clifton Atkins at this time.
Okay, okay, go, anything further from you, Mr. Black?
No, Your Honor.
All right, you may be excused. I'm gonna have to do a little bit of reading in order to make a final decision on this case, but I have the testimony. And so, we'll move on and bring in, Ms. Cribbs.
Yes, sir.
Thank you.
No.
Yes, and I'm working on my video. Okay, here we go.
Good morning.
Good morning.
Good morning. All right. Ms. Parado, your witnesses remain under oath, so you may proceed.
Okay. And Ms. Franklin, we are here today also asking the court to appoint you as the independent administratrix of the estate of your grandmother, Mary Darlene Atkins.
Yes,
And have you had an opportunity to review the proof of death and other facts and also the oath of independent administratrix?
yes,
And is everything true and accurate to the best of your knowledge?
yes, it is.
I pass the witness.
Any questions, Ms. Chris?
I have no questions, Your Honor. I've put everything in my report and I have no questions of either witness, actually.
Thank you.
And Your Honor, at this time, I would call Kevin Moore.
Right ahead.
Kevin Moore, have you had an opportunity to review the affidavit of facts concerning the identity of the heirs of of the estate of Mary Darlene Atkins?
Yes, ma'am.
And is everything true and accurate to the best of your knowledge?
Yes.
I pass the witness.
No questions.
Okay. And next I will call Carolina Batista. Ms. Batista, have you had an opportunity to review the affidavit of heirship or the affidavit of heirship or the affidavit concerning the identity of the heirs of the estate of Mary Darlene Atkins?
Yes.
And has everything, or is everything that in that document that you read true and accurate to the best of your knowledge?
Yes, it is.
Okay, I'll pass the witness.
And I have no questions, Your Honor. I've already spoken with the witnesses and have put all my information in my report, which I would ask you to accept.
Very good. Accepted. All right, Ms. Peraza, if you'll get them to sign all those proofs, you can file those with the county clerk. And then we will, I'll read through everything this afternoon on your briefing on the issue of the inheritance rights of the child whose parental rights were terminated.
Yes,
Your
sir.
Honor.
Thank you.
That's on another case. Go right ahead.
As an aside, I was watching, trying to monitor, the courtroom so I could see about when I'd be up because I'm out at juvenile court. And I was watching you and you were, telling the lawyers you kind of had to rush them through the questions and all because, you needed to get to the storm. And I was thinking, did something just pop up out of nowhere? Well, it was weeks ago that I was watching. So I got with it when I figured out what I was like, what?
All right, thank
Well,
y'all.
thankfully, we appear to be in good shape. We don't have any hurricanes threatening us right now.
Oh, thank God.
Y'all have a
Okay.
great week and let me know if you need anything, Ms. Barrazo.
Yes, sir. Thank you very much.
Thank
Thank you,
you.
sir. Ma'am.
Bye-bye.
McCall?
Has three, so I'm not sure which one is first.
Okay, let's see, yeah. Jones, Newby, and Gensel. Gensel. Self-proof, self-proof, self-proof.
Woo-hoo.
Good morning. Who do you have first, Mr. McCall?
Miss Harrison? Oh, this is,
Okay, that's on the Gensel case.
yes, Your Honor.
All right, Ms. Harrison, if I get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
Yes, sir.
Okay, Ms. Harrison, I'm going to hold up what purports to be the last will and testament of Bonnie Gensel. Do you recognize that as being her will?
I do, yes, sir.
And I'm going to go back to the signature page. Ask you, is that her signature on that document?
It is.
And after the date she made this will on April 6th of 1998, did she ever change it or revoke it?
No, sir.
Okay, go right ahead, Judge McCall.
Thank you, Your Honor. You've had an opportunity to review this proof of death and other facts before you came in today,
Correct.
and all this information is true, correct?
It is.
Go ahead and sign that for me.
October.
Go ahead and sign your oath too.
Okay, Ms. Harrison, so once she's notarized your signature on that proof and the oath, I'll sign the order admitting your mother's will to probate and authorizing the county clerk to issue letters of testimony that will give you authority to act on behalf of the estate. The letters will allow you to deal with financial institutions, insurance companies, real estate title companies, and so forth. If you'd please make sure that you cooperate with Judge McCall in getting him a listing of the assets of the estate, because he has 90 days from today to file an inventory with the court, okay?
Okay, thank you, Your Honor.
You bet.
Thank you, Judge. Everything's been signed and notarized.
All right, the order's signed. I hope everything goes well. Let us know if you need anything. And we're gonna go to newbie.
Okay. Yeah, we need here just a second. I'll be good.
I can't read this.
Oh,
I'm having to use I can barely read this death certificate.
Oh, I know.
Okay, it appears that Ms. Newby died of drowning in Sabine Pass
Yes, sir.
at the age of 73. Okay, Mr. Newby, if I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this cause should be the truth, so help you God? Okay, Mr. Newby, I'm going to hold up what purports to be the last will and testament of Ginger Newby. Do you recognize that as being her will?
Yes, sir. Yes, sir.
Go back to the signature page and ask you if that's her signature on that document.
Yes, Your Honor.
After the date she made this will on September 26th of 1995, did she ever change it or revoke it?
No, Your Honor.
Go right ahead.
Thank you, Your Honor. Mr. Newby, we had an opportunity to review this proof of death and other facts before you came in today to do the hearing.
Yes, sir.
And is all this information true and correct?
Yes, sir.
Can we get you to sign it right here? This is your oath. You sign it as well.
Mr. Newby, where is Michael E. Newby?
He is in Groves, Texas. Is it Jefferson County? Yes, sir.
Okay, did we have a waiver from him?
I haven't filed that yet, Your Honor.
Oh, okay, because it looks like, oh no, I thought he appointed Michael first. He appointed Daniel first. Okay, I'm just reading it wrong. My mistake.
I've got to send him, let's get him to sign a notice, Your Honor. He's a heir under the estate. I haven't
Yeah.
filed it.
Okay. So has he signed his proof of death and other facts?
Yes, sir. Everything's been signed and notarized, Your Honor.
All right, so Mr. Newby, you're gonna need to cooperate with Judge McCall on getting him a listing of the assets of your mother's estate because he has 90 days to file an inventory, but he'll be able to e-file those documents you just signed and get you letters testamentary that will give you authority to act on behalf of the estate. So I hope everything goes well. And he has one more hearing, so I think he's gonna excuse you, but I hope everything goes well. You take care of yourself.
Thank you, Judge.
Thank you.
Jones,
Hey, Dan, if you could,
trustee.
there she is.
Good morning, you Miss Trustee.
Yes, sir.
All right, if I could get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
Yes.
Miss Trustee, I'm going to hold up what purports to be the last will and testament of Tom Jones Jr. Do you recognize that as being his will?
Yes, I do.
I'm going to go back to the signature page and ask you, is that his signature on that document?
Yes, it is.
And after the date he made this will on August 30th of 2016, did he ever change it or revoke it?
No, he didn't.
Okay, go right ahead, Judge McCall.
Thank you, Your Honor. Ms. Newby, Ms. Trustee, excuse me, we had an opportunity to review this proof of death and other facts before you came in today for the hearing.
Mhm.
And is all this information true and correct?
Yes, it is.
I'm just going to go ahead and sign that.
Okay, Ms. Trustee, after those documents have been notarized, I'll sign the order admitting Mr. Jones' will to probate and authorizing the county clerk to issue letters testamentary that will give you authority to act on behalf of the estate so that you can marshal the assets of the estate and distribute them in accordance with the terms of the will. Please make sure that you cooperate with Judge McCall in getting him a listing of the assets of Mr. Jones' estate because he has 90 days from today to file an inventory with the court, okay?
Okay.
We all done?
Yes, Your Honor, she just finished.
All right, I've signed the order. Y'all let me know if you need anything. Y'all have a great week.
Thank you, Judge.
Thank you.
Appreciate it.
Care. Gladiolus. Good morning, Mr. Legislator.
Good morning, Your Honor.
Okay, you John L. Johnson, also known as John L. Lay D.
Yes, sir, Your Honor. Good morning.
Good morning. If you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth to help you God?
Yes, sir, I do.
Okay, I'm gonna hold up what's reported to be the last will and testament of Doretta Christine Lay. Do you recognize that as being her will?
Yes, sir, I do.
I'm gonna go back to the signature page. Yeah, ask you if you recognize that as being her signature.
Yes, sir, that is.
After the date she made this will on January 8th of 1991, did she ever revoke it or amend it?
No, sir, not that I'm aware of.
Go right ahead, Mr. Latchley.
Good morning, Ms. Johnson. Have you had a chance to look over the document entitled Proof of Death and Other Facts?
Yes, I have.
And is everything contained in that document true and correct to the best of your knowledge?
Yes, it is.
And did Doretta Christine Lee pass away on May 26, 2021?
Yes, that's correct.
And at the time of her death, she was a resident of Jefferson County, correct?
Yes, that's right.
And after the date of her will of January 8th, 1991, were any children born to or adopted by Mrs. Lee?
No, there were not.
At this time, I'm asking Your Honor to sign the order admitting Ms. Lee's will to probate.
Okay, so what's gonna happen, Ms. Johnson, is you're gonna make arrangements to sign your proof and your oath before a notary public. Get those to Mr. Latchley. He'll e-file those with the county clerk. When he does that, I'll sign the order admitting the will to probate, authorizing the county clerk to issue letters testamentary. They'll give you authority to act on behalf of the estate so that you can deal with banks or real estate title companies or whatever.
Okay.
Please make sure that you cooperate with Mr. Latchley in getting him a listing of the assets of your mother's estate, or is it stepmother?
Stepmother, yes, sir.
Yeah. Because he has 90 days from today, from the date I signed the order, within which to file an inventory with the court, okay?
Yes, sir.
All right, I hope everything goes well. Let us know if you need anything, Mr. Latchley, and we'll be stand ready to help if there's any way we can.
Okay, thank you, Your Honor.
I'll take
Thank you so
care.
much.
All right.
Okay, I think Mr. Brinkley's next on to check on one thing.
Okay.
Page, and my husband called you out on it. This looks like you're self-promoting on your official page or whatever. So that he.
Hey, good morning, Melissa. Can you hear me?
Yes, I can hear you.
Good.
What do you have first?
The Craig estate.
Okay. Okay, great. We'll start momentarily. Judge just stepped out for a second, okay? Okay.
There we go. Good morning, Judge.
Good morning, Mr. Brinkley. Give me 1 second.
Sure.
Okay, so we're on the Betsy Ruth Craig. I'll tell you one thing, there is no way in the world that I'm going to accept the two disinterested witnesses you have there.
Hi, Jeff.
I'll tell you what, when I get them under oath, I'm going to have a few questions of my own.
See you later.
Let me finish. Let's see here. All right, if I could get the witnesses to raise your right hands, please. Mr. Brinkley, can you get Ms. Craig in there too?
Yeah, here we go.
Okay. Do you and each of you solemnly swear or affirm the testimony you're about to give in this call shall be the truth, so help you God? Okay, go right ahead, Mr. Brinkley.
Thank you, Judge. Judge, for my first witness, I'll call Mrs. Janet Quibido. Mrs. Quibido, we've visited today about the estate of Patsy Ruth Craig. Is that correct?
Yes, sir.
Okay. My understanding is that you have known her since the 1960s. Is that correct?
Yes, sir.
Okay. You were married to her husband. Is that what I understand?
No, her husband was my brother.
I'm sorry, her husband was your brother. Very good. Okay. You've had an opportunity to read the affidavit of facts concerning the identity of heirs. Is that right? And is everything on there true and correct to the best of your knowledge?
Yes, sir.
Judge, I'll pass this witness.
Any questions, Mr. Dishman? I've read your report.
No questions, Your Honor. We've already spoken.
Thank you, sir.
Okay, Judge.
Go right ahead,
My next
Brinkley.
witness, I'll call Mrs. Betty Elliott. Miss Elliott, you've also had a chance to discuss the estate of Patsy Ruth Craig. Is that correct?
Correct.
Okay. And my understanding is you and Miss Quibido are sisters. Is that correct?
That is correct.
Okay, and my understanding is that you have known, you knew Patsy Ruth Craig and her family for the same amount of time as your sister, is that correct?
Correct.
You also have had a chance to look at the affidavit of facts concerning the identity of heirs, is that correct?
Yes, sir.
And everything on there is true and correct to the best of your knowledge?
Yes, sir.
Okay. Nothing further for this witness, Your Honor.
No questions for this witness, Your Honor.
Thank you, Mr. Dishman. Go right ahead.
At this time, Your Honor, I would call Susan Craig. Okay. Susan, you are the daughter of Patsy, is that correct?
Yes.
Okay. And you have heard the testimony of these two witnesses and you agree that they have reported the family history correctly?
Yes.
Okay. You've also had an opportunity to look at the proof of death and other facts that we prepared, is that correct? Okay. And everything on there is true and correct to the best of your knowledge?
Yes.
All right. And you're asking the court to appoint you in the position of independent administratrix, is that correct?
Yes.
Okay. Nothing further for this witness, Your Honor.
All right. Do you have a notary there, Mr. Brinkley? Okay, let me know when their proofs are signed.
Okay.
Mr. Dishman,
Everything is signed and ready to go now.
it is?
Yes, sir.
Well, that's pretty efficient.
Very efficient.
Mr. Dishman, I don't see an order on your attorney's fees.
I believe I filed it with the motion and report at the same time.
Let me see if it's attached to the report.
What court expects to be paid today?
Hopefully.
There it is. I found it. Well, it's the second mistake I've made today.
Very good.
All right. Ms. Craig, Ms. Craig, I have signed the order, the judgment declaring heirship and the order authorizing independent administration of the estate. So once Mr. Brinkley e-files those documents that y'all have just signed, he'll be able to get you letters of administration from the county clerk. The letters of administration will give you authority to act on behalf of the estate. So if you need to deal with financial institutions, real estate title companies, anything of that nature, you'll use those documents to do so. please make sure that you cooperate with Mr. Brinkley in getting him a listing of the assets of your mother's estate because he has 90 days from today to file what's called an inventory appraisement and list of claims with the court. But otherwise, I hope everything goes well. And if y'all need anything, just let me know. And Mr. Brinkley has one more case.
Yes, sir.
And I guess Betty and Janet, y'all try to stay out of trouble this week if it's at all possible.
I'm going to a luncheon today. You going?
Huh?
You're gonna make the luncheon today?
If I get out of hearings, I might.
Well, let's let you go. See you later.
Y'all have a great one.
All right, ladies, I'll catch up with you guys. Thank you for coming
Thank
today.
you.
Nice to meet you. And I'll catch up with you. Bye, Susan. Good to see you. We'll talk. Bishop. Right here, Mr. Tucker. He's going to show you a copy of the will, Mr. Tucker.
Good morning, Mr. Tucker.
Good morning, Judge.
All right, if I could get you to raise your right hand, please, sir. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
I do.
Okay, Mr. Tucker, I'm going to hold up what purports to be the last will and testament of Karen A. Tucker. Do you recognize that as being her will?
I do.
Okay, and I'm going to go back to the signature page and ask you, is that her signature on that document?
Yes, it is.
Okay, and after the date she made this will, on December 16th of 1998, did she ever change it or revoke it other than by the first codicil?
No.
Okay, now I'm going to show you what purports to be the first codicil of the will of Karen A. Tucker. Do you recognize that?
I do.
And likewise, is that her signature on that document?
Yes, it is.
Okay, go right ahead, Mr. Brinkley.
Okay, thank you. Okay, Mr. Tucker, you and I have had the chance to visit today, and I've showed you this document called the Proof of Death and Other Facts. Is that correct?
That is correct.
And is everything on here true and correct to the best of your knowledge?
It is.
Okay. Judge, I have no further questions for this witness, and I'm gonna have him sign the proof of death.
Okay, let me know when that's notarized, please, sir.
You got it. Okay, Judge, the proof of death and other facts on the oath have both been signed.
Okay, are they notarized yet?
Yes, sir.
All right, Mr. Tucker, I have signed the order admitting the will to probate and authorizing the clerk to issue letters testamentary. I hope everything goes well. I'm so sorry for your loss. Let us know if there's any way we can help.
Thank you very much.
Y'all have a great week. Take care now.
Thank you.
It looks like Mr. D. Cordova. We got a bunch of unapproved ones today.
Morning, Judge.
Good morning. I can hear you, but I cannot see you yet. And I cannot see Mr. Johns either.
Yes, Your Honor, I'm trying to figure that out. Why is that?
Bottom left-hand corner of your screen, if you have a touch screen, there you go. You got it.
There we go. Let me turn mine.
Okay, Mr. D. Cordova, you should have James Hoy, Paul Hoy, and Karen Lyon there with you. Is that correct?
Yes, sir. Folks, give me a step over here.
Is there a way I could see all three of them?
Yes, sir.
All right, if you raise your right hands, please. Do you and each of you solemnly swear or affirm the testimony you're about to give in this call shall be the truth, so help you God? Okay, go right ahead, Mr.
Okay.
DeCordova.
Well, thank you. I will proceed with Karen
Karen.
Line. There you go. There, right there. I'm giving those to you. And I do have the notary in the room with me, Your Honor. This line, we'll step over here, Karen. So, you're the applicant in this case, and you're the sister. You have to speak up and say yes.
Yes,
Right,
sir.
okay, and you're the sister of James Michael Bernard,
Yes, sir.
and he passed away on November the 5th, 2020.
Yes, sir.
Okay, I'm going to show you a document called Proof of Death and Other Facts that was filed July 14th, 2021 in this probate proceeding.
Yes, sir.
And you're familiar with the facts stated in this document,
Yes, sir.
and we've gone over it several times. correct?
Yes, sir.
And the facts are based on your personal knowledge.
Yes, sir.
Okay. Sir?
I'm looking for a death certificate. Here it is.
Okay.
Go right ahead.
Right. Okay. Okay, that's all the questions I have for Ms. Line.
Okay, you'll go to the disinterested witnesses, please.
Yes, Karen, sit over here. Okay. Mrs. Hoy? We'll do this right there. You're Paula Jeanette Hoy,
Yes, I am.
and you knew James Michael Bernard for nearly,
Since at least 84, since 1984.
okay. And I'm going to show you a document that's called Affidavit of Disinterested Witness Facts concerning identity of heirs. And you were familiar with this document?
Yes, I am.
Okay, we've gone over it quite a few times, correct?
Yes.
And the facts stated in this document are based on your personal knowledge.
They are.
And they're true and correct.
Yes.
All right, thank you. Mr. Hoy? Your name is James Michael Hoy?
It is.
And I'm showing you a document called Affidavit of Disinterested Witnesses, of Witness of Facts concerning identity of heirs. And do you have personal knowledge of the facts stated in here?
I do,
Yes.
yes.
You've reviewed this before?
Yes, sir.
And the facts stated in this document are true and correct?
They are, yes, sir.
All right, thank you.
Okay, do you have any questions of these witnesses, Mr. Johns? I've read your report.
Your Honor, my report is true and correct, I believe. I'd like to, let me take Miss Paula, the witness, Paula Hoy on. Ms. Hoy, my name's Kent Johns. I'm Ned Lightem on this case. I visited with you sometime in September. Is that right?
Yes, you did.
And you told me that you knew the deceased person, James Michael Bernard, for over 30 years, correct?
Yes, that's correct.
And you knew him not to have any children or have adopted any, and that his only two relatives were Paul Bernard and Karen Louise Lyons. Is that correct?
Philip
Couldn't-
Menard, yes.
Menard, yes, okay. And you knew those to be the only heirs of this estate. You don't know of any other children adopted or otherwise?
No, I don't know of anyone else.
Okay, no outside children?
No, sir.
Okay, I'll pass the witness, Your Honor.
All right, anything further?
Nothing further.
All right. You told me you had a notary there, Mr. DeCordova?
Yes, sir.
Okay, go ahead and get the witnesses to sign their statements and their proofs and let me know when those are notarized.
Karen.
Yeah, so Karen just needs to sign.
Oh, sorry.
It's okay.
Let me do the Chisholm estate.
Karen?
Well, the oath, but that can,
Okay,
that's gonna be done separately. Okay, that's for you right there.
Johns, you may be excused if
Thank
you
Your
will.
Honor, I appreciate it. You
Thank
have
you.
a good day. Thank you, sir.
You
Thank you,
too.
Mr. Johns, appreciate your
All
help.
right. Take care.
And Your Honor, they're all signed and notarized. The two affidavits and the proof of death and other facts.
All right, Ms. Lyon, I have just signed the judgment declaring heirship and the order authorizing independent administration. Mr. D. Cordova will e-file those documents with the county clerk and be able to get you letters that will give you authority to act on behalf of the estate. Please make sure that you cooperate with him in getting him a listing of the assets of your brother's estate, because he has 90 days from today's date to file an inventory with the court, okay?
Okay.
And Your Honor, I'll also be filing the.
Thank you. Y'all take care.
I'll also be filing the oath.
Very good.
All right, thank you.
Okay, where is Max Johnson?
I'm not hearing. Hold on one second. Okay, can you hear me, Judge?
I can. Where's Max Johnson?
Sorry. Sorry, my mic was off. I mean, my thing was off, so I didn't hear you. I'm sorry.
Okay, where is Max Johnson?
He and Desiree are in the same room, so they should both be room. And then Eunice.
You know what device? Oh, here's the Sarah.
Okay. Are you Sahara mentioned?
I'm Shahara, yes.
Okay.
Johnson.
Is Max Johnson the same person as Max Quisha Johnson?
No, they're not the same person. Desiree and Max are on the same computer, and then Eunice is the other witness that's on a separate partner.
Okay, you are Desiree Green,
Yes.
and are you Max Johnson?
Yes,
And what relationship are you to the decedent?
that was, I'm the grandfather.
Max.
The grandfather of Justin Avery Chisholm Jr.?
Yes.
Okay, so we're looking for Eunice Johnson. We don't have any anyone out in the waiting room that has that name.
Is it Christy Griffin, but I don't know who that is.
Okay, let's go ahead and Ms. Green and Mr. Johnson, if you'll raise your right hands, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth so help you God?
Yes.
Okay, go right ahead, Ms. Mention.
Yes, Your Honor. Mr. Johnson, can you please introduce yourself to the court?
Yes. My name is Max Johnson.
And you are the grandfather of Justin Avery Chisholm Jr., is that correct?
Yes.
And you're asking to be the independent administrator for his estate, is that correct?
Yes.
And Justin passed away at the age of 8 years old, is that correct?
Yes.
And he died on March 20th, 2021, is that correct?
Yes.
And he has two parents, Maxquisha Johnson, is that correct? His mother?
Yes.
His father, Justin Avery Chisholm Sr., is that correct?
That's correct. Yes.
Okay. And when he passed away, there was a special need trust, is that correct, that needs to be administered?
Yes.
Okay. And to the best of your knowledge, well, he was 8 years old, so he did not have a will, is that correct?
Correct.
And he was never married and didn't have any children?
No.
The only debt that he has that's for the estate is for Medicaid, Medicare, is that correct?
Correct. Yes.
And do you have any reason why you could not be the administrator for the estate?
No.
I don't have any further questions for Mr. Johnson.
Mr. Celeste?
No questions, Your Honor. My report is on file with the court. I spoke with Eunice and Desiree, and again, I'm satisfied with the facts and the heirs stated in the application.
Okay, I guess my question, Ms. Mention, is why is the grandfather of the decedent as opposed to the parents applying for independent administration?
We just believe that it would be easier, Your Honor, and more efficient for one person to be able to do this. There's just a lot of emotions, I would say, with the parents left, and we still got a lot of things that need to be done. So we believe that it would be in the best interest of the estate for Mr. Johnson to handle it. It would just be easier.
Okay, did we ever have anybody named Denise Johnson come on there?
She says her name on the screen is Christy Griffin. So just say.
Okay, Ms. Green and Mr. Johnson, you're going to need to make arrangements with Ms. Meacham to sign your proofs and your statements of disinterested witness before a notary public. She'll then e-file those with the county clerk, and we'll move forward from that point. Mr. Celeste, we're trying to bring on Ms. Johnson right now.
Understood. I think we see her, at least I see her at the top. She just has to turn on her video, I think.
Ms. Johnson, can you hear me?
Yes.
Okay, there you are. If you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call shall be the truth to help you God?
Yes.
Okay, go right ahead.
Ms. Johnson, can you please introduce yourself to the court?
Yes. Hi, my name is Eunice F. Johnson.
And how did you know the decedent Justin A. Chisholm Jr.?
He's my nephew.
And how long did you know him?
Since birth.
And he was 8 years old when he passed away, is that correct?
Correct.
And he died on March 20th, 2021, is that correct?
That's correct.
And he was not married and did not have any children. Is that correct?
That's correct. He
Right.
wasn't.
Okay. And his mother is Masquisha Johnson. Is that correct?
That's correct.
And his father is Justin Chisholm Sr. Is that correct?
Yes, that's correct.
And he did not have a will. Is that correct?
That's correct. He did.
And as far as you know, the only debt that he had to his estate was for the Medicare, Medicaid. Is that correct?
That's correct.
And as of yet, there's been no administration. No one's taking care of his estate at this time. Is that correct?
That's correct.
Any questions, Mr. Celeste?
No, Your Honor. Thank you.
All right. If you'll make arrangements to take care of getting those documents e-filed and let the court know, and we'll take care of your orders for you.
All right. Thank you, Judge.
All right. Y'all have a great week. Take
All
care
right.
now.
Bye-bye.
You too.
Okay, Mr. Dowden.
That's three. Which one is first? Not self-proven first.
See who he's got in there.
Got it.
Can you hear me, Judge?
I can hear you, but I can't see you.
Oh, Lord, wonder what that's all about. And who's first?
Look, start ready again.
Why don't we go with Russell first?
She's a lot of trouble, let me warn you.
I know she is.
I mean, she's like the biggest trouble for Jason Burden at First Baptist. Deanne?
Deanne Tanner.
Deanne,
You are up.
we're not, nope, not much favorably being said about you in here. You better come on in.
Being ugly about you.
Shocking. I would have been dealing
Here.
with her there.
There you go. Have a, okay, there you go. There she is, Judge, the one and only.
The one and only.
Yeah, I can just tell you right now, you're in a heap of trouble, girl.
I'm telling you, Judge, with you and this one to my left,
Yeah.
I think I'm in pretty good company, actually.
You're just trying to get
Suck
up to us.
Okay, Deanne, if you'll raise your right hand.
Hey, Judge, I'm sorry, so sorry to interrupt, but here comes Nina. That we, for whatever reason, only could find a copy, but Chris and Nina witnessed. So Nina's gonna take the oath too, if you don't mind, and help us prove up the will.
That'll be fine. All right. Do you and each of you solemnly swear or affirm the testimony you're about to give in this call shall be the truth so help you God?
Yes, I do.
Okay, I'm going to show you what purports to be a copy of the last will and testament of Joyce Nalene Beeks Russell. Do y'all recognize that as being a copy of her will?
Yes, sir.
I'm going to go to the signature page and ask you, is that a copy of her signature on that document?
Yes, sir.
And Nina, is that a copy of your signature as a witness to that document?
It is. Yes, sir.
Okay, go right ahead, Mr. Dowden.
Thank you, Judge. So, Ms. Tanner, you're here today regarding the estate of your mom, Joyce Nell-Lynn, I practiced that,
Nell-Lynn.
Biggs Russell, is that true?
Yes.
And I understand she passed away on her about May 19th of this year, 2021, is that true?
Yes.
And you've identified her May 4th, 2017 will, is that true?
Correct, yes.
And a while ago, you had an opportunity to look over the proof of death and other facts we're filing with the court today, is that right?
Yes, sir.
Everything in that document's within your knowledge and true and correct, is that right?
Yes.
And you have an oath here, you promised Judge Brannick you'll take care of your mom's estate to the best of your ability, is that right?
Yes, sir.
And Judge, if I could ask Ms. Dowd, Nina, you've looked over this proof of by subscribing witness and everything in that document is true and correct, is that right?
Yes.
Okay. And who's the man of your dreams? Okay. Okay.
Under oath, great.
Okay. So that's all we have, Judge, unless you need anything further.
Let me know when everything's notarized, please.
Yes, sir. You'll sign that there.
While you're notarizing, I'm gonna go get some more coffee.
Okay, Judge.
Gotta have that coffee.
Oh, never mind. They brought me some in the courtroom.
That's him. Or else Tina, either way.
Do I need to date it?
They'll date it, Tina will date it.
So long.
Okay, Deanne, once everything's notarized, I'll sign the order admitting the will to probate and authorizing the clerk to issue letters testamentary that'll give you authority to act on behalf of the estate. You'll need to cooperate with Larry in getting him a listing of the assets of the estate because he's got 90 days to file an inventory. If you don't file it within that time period, then we send the secret police after you to arrest. Undisclosed location.
How many pages do we have for the inventory? Because that's a lot of inventory.
I think they're already looking for him, maybe, Judge. So, okay, well, thank you, Judge. Who's next?
Appreciate you, Judge.
You got it? Everything notarized?
I'm sorry, yes, sir, it's all done.
All right. The order is signed and we will, we'll go to Pearson.
Pearson, yes, sir.
Thank you much, Judge.
Take care.
Miss
Ah,
Pearson,
you too,
ready?
sir.
I'll send you everything.
Yes. and
Thank you,
I'll
babe.
do it.
Yes.
See you in a little bit.
Okay.
See you, Deanne. Take care.
Bye. Thanks, sir.
There you go. Have a seat there. We'll slide you up and make sure Judge can see you in this window right there. Okay.
Okay. Do I need to take my mask off?
It's if you, yeah, you know, I guess so. I'll be fine. Not sure. If remember the answer to that. I think if you want to.
Can you bring that camera down a little bit?
Yeah, I'm sorry. You're right, Judge. Okay, here we go.
Good morning, Ms. Pearson.
Good morning.
All right, if I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth so help you God?
Yes.
Okay, Ms. Pearson, I'm going to show you what purports to be the last will and testament of Charles E. Pearson. Do you recognize that as being his will?
Yes.
I'm going to go back to the signature page and ask you, is that his signature on that document?
Yes, it is.
And after the date he made this will on May 23rd of 1988, did he ever change it or revoke it?
No, he did not.
Go right ahead, Mr. Dowd.
Thank you, Judge. Ms. Pearson, I understand that your husband passed away on or about April 15th of this year, 2021. Is that true?
Yes.
And have you had an opportunity to look over the proof of death and other facts that we're filing with the court today?
Yes.
Everything in that document is within your knowledge and true and correct. Is that right?
Yes.
Also, you'll sign for Judge Rannick an oath this morning. Have you had a chance to look over that oath?
Yes.
You'll take care of the affairs of your husband's estate to the best of your ability. Is that true?
Yes.
Okay, if you'll sign, Judge, that's all we have unless you need anything further. You'll sign right there.
No.
Thank you, ma'am.
All right, Ms. Pearson, once everything's notarized, I'll sign the order admitting the will to probate and authorizing the clerk to issue letters that will give you authority to act on behalf of the estate. Please make sure that you cooperate with Mr. Dowden in getting him a listing of the assets of the estate because he has 90 days to prepare and file an inventory with the court, okay?
Okay.
And Judge, we're signed and notarized.
All right, we're good to go. And if you can bring in Morrison.
Yes, sir. Thank you, Judge.
Take care,
Before I
Ms.
go,
Pearson.
I want to thank you for all you do.
Thank you so much, Ms. Pearson. You have a great week.
Thank you, Judge. Thank you, Ms. Pierce. We'll be in touch with you. Tina will send you the little form to start on that inventory, okay?
And you can ask me any questions.
Yeah, if you have questions, holler at us.
Okay, thank you.
Carolyn?
Then you'll send me the form. Yes.
I'm at my office. I'm supposed to drop off some stuff on the bill.
We're full of relate.
I called last week.
Do you know if you talked to Larry?
Here you go. Have a seat right there.
Larry, you want to sit here too?
Y'all, hey, Kevin, y'all just stand back there if y'all want to be here for moral support. We appreciate it. Okay, this is Miss Carolyn Morrison, Your Honor.
Good morning, Ms. Morrison.
Good morning, sir.
All right, if I could get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
Yes, sir.
Okay, Ms. Morrison, I'm gonna hold up what purports to be the last will and testament of James Weldon Morrison. Do you recognize that as being his will?
Yes, sir.
I'm gonna go back to the signature page and ask you, is that his signature on that document?
Definitely.
And after the day he made that will on September 3rd of 2020, did he ever change it or revoke it?
No, he did not.
Okay, go right ahead, Mr. Dowden.
Thank you, Judge. Ms. Morrison, Mr. Morrison passed away on or about July 10th of this year, 2021. Is that true?
Yes.
And this morning you had an opportunity to look over the proof of death and other facts that we'll be filing with the court today. Is that true?
Yes.
And is everything, all the information contained in that document within your knowledge and true and correct?
Yes.
Also, we'll file with Judge Brannick an oath this morning, and you promise, Judge, that you'll take care of the affairs of your husband's estate to the best of your ability. Is that right?
I will.
Okay, Judge, that's all we have unless you need anything further. We'll sign and notarize. If you'll
Go right ahead.
sign right there.
I see, they put my name on my cup so I could remember who I
I
am.
like that. I like that. Might need to do that for the president. No. Sorry, that slipped out.
And this one?
Yes, ma'am. I'm impressed they brought it. They bring it to you. Nobody brings me anything around here.
Little kindness goes a long way, Mr. Dowden.
Maybe so.
Okay, Mrs. Morrison, since those are notarized, I'm going to sign this order that will admit Mr. Morrison's will to probate and authorize the county clerk to issue what are called letters testamentary. Those letters are what you're going to use to show your authority to act on behalf of the estate. So if you need to deal with real estate title companies, financial institutions, insurance companies, those letters will allow you to do so. You will need to make sure that you cooperate with Mr. Dowden in getting him a listing of the assets of the estate, because he has 90 days from today to file an inventory with the court. But other than that, I know he'll do a great job of guiding you through the process.
Yes, sir.
Thank you, Judge. We are signed and notarized now. Appreciate your help.
All right, the order is signed, and if you need anything else, please feel free to give me a call, Mr. Dowden. Y'all have a great
Thank
week.
you, Judge. Have a great day. Thank you, Judge. Bye-bye.
On the regular docket.
Can you hear me, Mr. Scott?
Yes, sir.
Okay. Is Ms. Provo going to be attending?
I'm looking for her now.
No, Your Honor, I'm appearing on behalf of the administrator.
Okay, what about Mr. Garrett?
I hear you loud and clear, Your Honor.
Okay, I can hear you, but I can't see you and I can barely hear you. Bottom left-hand corner of your screen, all right?
I'm unmuted.
Okay, and then we have Michael Gramillion. Can you hear me, Mr. Gramillion?
Yes, sir.
Chester.
Okay, where is Chester Gramillion?
Your Honor, Chester Gramillion is not present. It was my understanding that this is a motion to compel an accounting.
Yes.
And so
And the distribution. Okay, this is your motion, Mr. Garrett. I'll let you move forward.
Thank you. We call Mr. Mike Vermillion to the witness stand, Your Honor.
Mr. Gramillion, if you raise your right hand, please. You solemnly swear or affirm the testimony you're about to give in this call should be the truth so help you God.
Yes, sir.
Okay, go right
May
ahead.
I proceed, Your Honor? Thank you.
Please.
Would you please state your full name for the record, sir?
Michael Harris Gramillion,
Where do you currently reside?
4312 Matt Drive in Killeen, Texas, 76549.
However, where were you born and raised?
Beaumont, Texas.
What is your current occupation?
I'm currently unemployed. I separated from the military.
Are you disabled?
I am disabled, 100%.
Generally, how long have you been disabled?
Roughly since 2014.
Okay, what is your relationship with the deceased, Miss Lottie Gramillion?
It's my mother.
Okay, and she was deceased or is deceased as of December 2017. Is that correct?
Yes, sir, that is correct.
Okay, and you are,
I'm
I'm sorry?
Administration.
I'm sorry, Your Honor.
I was talking to my clerk and asking her a question. I am more than willing to continue to hear the testimony. But I guess I'm more interested in hearing from, let's see, it looks like, Mr. Scott, I'm more interested in hearing from you right now because it appears as though the letters of administration were granted January 17th of 2019. It's now been more than 2 years. You know, my practice in my court is that if there's not an ongoing business or ranching operation in the estate, it should be closed out within 6 months. And we are way, way past that. And I'm trying to figure out why we're still here today.
Your Honor, I did file an accounting recently. There's some changes I have to make to the accounting. And I'd like to give you a background of what's been going on. There was Mr. Gramillion had a previous lawyer, and we've been gathering information, exchanging information. My client has had his deposition taken. And so I got on the case. I got on the case after the letters have been issued. And so it's just been a matter of getting on top of all the information, getting the accounting done, catching up. The previous lawyer and I did a lot of work. So to make a long story short, all that has been done. I did file an accounting, and there's not a reason that this estate will be open very much longer.
May I, Your Honor? May I respond?
Yes, sir. Yes, sir.
All right, I checked with the former attorney. I've been on the case for about 2.5 months. Mr. Brinkley, and I believe you're familiar with him. I'm sorry. Yes.
He appears here rather frequently.
Yes, sir. According to him, and also according to my own independent review, there has been no accounting file pursuant to 404001. That's why he filed this motion. He amended this motion, and we're simply following up on the motion that he filed. And also, according to the deposition that he took, the independent administrator, Mr. Chester Gramillion, has actually written, heard over, and administered the estate since the death of his mother. He testified to that. And so while it did take almost 2 years to formally name him as administrator, in fact, he has been the, let's just say, the de facto administrator since December of 2017. And so as the court just recognized judicially, there has been no distribution and there has been no accounting done, at least since we'll just go from the date he was formally appointed. So my client is wondering, why has there not been a distribution? Why is this estate still open? I was just going to establish those facts with his testimony. The abbreviated version would be for the independent administrator's attorney to just agree we need to do a formal accounting and to sign off and agree on this order, or to have the court just sign the order and give the administrator whatever time the court deems is necessary for us to get an accounting done.
Okay, I can tell by, I don't really need testimony because I can tell by looking at my file that it's not been done unless I'm missing something.
You're not missing anything, Your Honor.
Okay, well, it's my understanding we did follow the accounting with the court. You know, I'm not making a misrepresentation to the court. I've been working on the accounting. An amended accounting needs to be filed, but I did file an accounting that I need to make some additions to.
No accounting according to.
If this will be agreeable to the parties, I'm going to give 3 weeks from today to get an accounting in.
Okay, no problem.
And I'm going to be really concerned if within 3 months this estate's not distributed, or the assets of the estate that are in real estate aren't put up for sale and converted to cash so that they can be distributed in accordance with the rules of intestate distribution. Because like one of my old law professors used to say, the longer a case sits around, the more it's like a fish. It starts to smell. And this has been hanging around way too long, and I really want to see it resolved and completed, Mr. Scott. So we're going to reschedule this for 3 weeks from today. Hopefully you will have been able to provide Mr. Gramillion's attorney, Mr. Garrett, with an accounting that satisfies them, and as well as get with him on a plan to turn the assets of the estate into cash or into some kind of like-kind distribution so that this estate can be closed. It's been around too long. Okay.
Okay.
Your Honor, just so we're clear, we just want an accounting that complies with Texas Estates Code 404001. We have not received that, and one of those has not been done. We need those questions answered so we can proceed forward to distribution or removal of the independent administrator.
I think Mr. Scott will do that. I trust that he will.
Okay, very good.
But we'll reschedule you for 3 weeks from today. If y'all have a problem, please contact the court and I'll be happy to talk to you. Together, y'all will both need to contact me, okay?
Sounds good.
You can call me by conference call or whatever. All right, thank you, gentlemen. I hope everything goes well. Y'all let me know if y'all run into any problems.
Okay, will you sign the order, Your Honor?
I'll have to look, let me look at it and see what it says.
Okay. We just follow the statutory requirements and the code. That's all.
Okay, that's what date?
25th.
Okay, I'm gonna sign the order that's got to be provided by October 25th.
Thank you much, Your Honor.
You gentlemen have a great day and
You
let
too,
me
Your
know
Honor.
if we can help.
You betcha. Thank you much. May we be excused, Your Honor?
Yes, sir. Y'all may be excused. Okay,
Kid, Grant,
who?
Kid Estate,
Okay,
independent, mental.
I read something about this.
He just put this on. The judge put this on.
Y'all give me a copy of the estates code.
Yes, sir.
Judge, my client, Chelsea Chandler, she's also available if we could bring her in.
Okay, we'll get that done in just a minute. I'm gonna run and grab a copy of a book. I can hear you, but I can't see you.
So, yeah.
Let's see. Oh, wait, there she is. Never mind.
Just give me handy. Oh.
Here's my docket sheet. That's the old docket sheet. Okay, let's see here. Mr. Graham?
That's me, Your Honor.
Oh, Ms. Graham. Pardon me.
No problem.
Ms. Graham, we're here today on a motion for independent medical examination that you filed. Mr. Hines is appearing on behalf of Chelsea Chandler, and Ms. Corcoran is appearing as an ad litem. Let me hear background on this, please, Ms. Graham.
Thank you, Your Honor. That was our motion that was filed. Mr. Bass is the nephew of the proposed ward, Ruby Kidd. Ms. Kidd was living with her longtime husband. When her husband passed away, his family became involved, and ultimately, Ms. Kidd's health was not really tended to. My client went and saw her. There were some serious concerns about her capacity. And Ms. Kidd's sister is also with Mr. Bass, my client. So the proposed ward sister is still alive.
Wait just a second. Let's make sure I understand that. Your client is the sibling of the proposed ward?
No, he is a nephew.
Okay.
His mother is the proposed ward's sister.
Okay. And and Mr. Hines, who is Miss Chandler?
So Miss Chandler is, so the proposed ward's husband, who died recently, they've been married for, I don't know, 30, 40 years. My client, Miss Chandler, is the granddaughter of the husband, but for her entire life, Miss Kidd, Mr. Kidd were married, and she considered her grandma and still treats her as such.
Okay, I see a Mr. Kenton Bass on here. Who is he?
That's my client, Your Honor.
Okay. And I see Miss Chandler signed on, but I can't hear her or see her.
I'm here. I didn't realize the camera wasn't working. I might have to do it from my phone instead of the laptop. I'm sorry.
What'd she say?
Her video's not working on her laptop. She can log in from her phone if needed.
No phones allowed. If you have a touchscreen laptop in the bottom left-hand corner, or you can hover your mouse, it should enable your video. Unless you have a laptop that does not have a camera on it.
No, sir, it was. I'm not sure why it's not connecting. Hold on just one moment. I'm so sorry.
I can't hear.
She was sorry. She's working on it.
Right. Ms. Corcoran, you're the ad litem. Have you had an opportunity to visit with the proposed ward?
Your Honor, I was appointed last week, September 28th, I believe. So my plan was to meet with the ward sometime this week and then speak with the parties if needed. So I haven't had a chance to do that yet, no, sir.
Okay, well, I guess, Mr. Hines, let me hear from you about the nature of your objection.
Your Honor, we filed our contest late last week, so I was unaware of this filing until I got the calendar reminder for the Zoom hearing on Friday, and I called Melissa to ask what it was about. So I didn't know if this motion had been filed, but I'm assuming it's because, my client has been and continues to be very involved. She has a power of attorney for her grandmother, both medical and durable general. If I'm assuming they have, our position is Mr. Bass doesn't really have a relationship and hasn't had one with the proposed board for as long as my client can recall. So I'm assuming it's because they're filing this motion because they have no control or anything else or any involvement with the proposed board. So my position, I'm not saying that she doesn't need to be evaluated if that's the position of the court. What I would suggest though is that when she went to Calder Woods, they had, she had been treated by Dr. Butte and his PA, Danny Thompson, for almost a decade. They actually examined her back in July for purposes of determining her condition as such was necessary for her to go into Calder Woods, because if she has a significant mental deficiency or something, then that determines whether or not she can be accepted into Calder Woods and what area of Calder Woods she would be placed. So if she needs to be examined, then my client can make those arrangements for her to be examined by her treating physician, which I think would be most appropriate. That's going to be the one who's most familiar with her condition anyway.
Okay, Ms. Graham, do you have any objection to the treating physician for the proposed ward being the individual who provides a report of their medical exam, independent mental evaluation of the proposed ward?
You know, Your Honor, I think 3 or 4 months ago, I don't think my client would have objected because the family was attempting to work together. But at this point, I think Ms. Kidd's step family has been so influential that I don't think the court would necessarily get a proper picture. Ms. Chandler has argued in her contest that the proposed ward has capacity. If that's the case, any physician, especially an independent physician, ought to be able to give this court a qualified examination. But if she does not, then I think it's fair that someone who is neutral and who's not been influenced by the step family would best be able to serve this court in determining whether or not a guardianship is appropriate. And obviously we know that this examination has to happen as part of a guardianship, but I think unfortunately the relationship has so deteriorated. And I would point out to the court that in the contest, Ms. Chandler states to the court that the powers of attorney were just executed July 23rd, which is less than 3 months ago. And that, you know, of course, they believe that she has capacity. But if there's been an ongoing physician, it doesn't make sense to me that they weren't able to provide anything to this court up until now. This situation has been deteriorating for months.
Your Honor,
so our request would be that it would be an independent physician.
Your Honor, if you don't mind, I mean, we just filed our contest and our position is she doesn't need a guardian. Obviously, we've got alternative allegations in there in the event the court does determine it, but I'm aware of no records unless Ms. Graham can point something out of some sort of bias or something by the treating physician. I mean, this guy's been treating her for a decade. That has nothing to do with, I mean, Mr. Bass, my understanding is he sees her once every few years and all of a sudden he's coming in and he knows what's in the best interest of the proposed ward. You know, and as a matter of fact, now that she's been at Calder Woods, Ms. Chandler's made arrangements for her to be seen by the nurse practitioner that actually does rounds at that facility, so she'll be monitored on a more regular basis. But sending her to an independent person who's going to see her for 1 hour, as opposed to somebody who's been treating her for a decade, I don't know how a person in 1 hour can make anything better. I mean, this just came up to us. This is something we planned or anything.
Is Miss Kidd in the memory care unit at Calder Woods?
No, sir.
Okay. Who is her treating physician?
Well, I guess she's been moved, and Ms. Chandler can probably answer that, but I think my understanding is she's been, she got her in to be able to be seen by Carolyn Williams, who's a nurse practitioner. And she's been being seen by Carolyn Williams, who does the rounds at the facility for the last month. Prior to that, it was Danny Thompson, the PA, and the Dr. Butte.
Okay, well, here's what I'm going to do. I'm going to set this hearing off for 2 weeks from today. And in the interim, that will give Ms. Corcoran the opportunity to go out and visit with the proposed ward. Also give you the opportunity, Mr. Hines, to get a report from the family physician that had been her physician for a while. We'll see what that report says and what Ms. Corcoran's initial feelings are about the mental status of the ward. And then we will take up the issue of another physician in the event that there is some dissatisfaction with the reports we have.
Okay.
But it appears that we're a little bit premature here, not having gotten a report from the family physician or the ad litem having had the opportunity to visit with the ward. So I want that information before we move forward. So we'll move you to the 18th at 10:30.
Your Honor, would you like us to do a notice of hearing for that?
Please.
Yes, sir.
All right, thank you, Judge.
Thank you. Y'all have a great week.
You too.
Bye-bye.
Hey, you want to take a break?
No, let's go ahead and, well, I'm gonna get a little bit more coffee. Pour this out. Oh. If y'all need to take a break and run the ladies'
Yes,
room.
can-
Yes, can
y'all
we?
go ahead.
Will you re-sign this for me?
Yeah.
This was on
And,
one page.
Let me see this file that we're fixing to have the hearing on. Maybe I can read a little bit of it.
Okay.
All right, who all have we got here? We got Mr. Partain, Mr. Quigley, and Mr. Celeste.
Morning, Your Honor.
Okay, Mr. Armstrong, who are you representing?
Andrea Rhodes, Your Honor.
Okay, and is that the sister of the applicant?
Yes, Your Honor.
Okay, and then Mr. Waters?
Good morning, Your Honor. I'm here on behalf of Paul Hilton and Philip Hilton.
We have a Carolyn and a Tina Lombardo. I don't know if they're part of this estate or not.
Okay, is there a Tina Lombardo that's supposed to be on this hearing?
Yes, Your Honor. She was a witness that I subpoenaed. She's the Edward Jones representative for.
Her on?
And a Carolyn.
Who?
Carolyn.
And then there's a Carolyn. Is there a Carolyn?
Yes, Your Honor. That's my client's sister-in-law. And my client, Kathy Wiles, will be with Caroline.
Okay, I'm gonna, as a general rule, I like to have everything read before I have a hearing, but we did not know this morning that there was going to be a hearing. Apparently someone had called on Thursday or Friday and canceled this hearing. And so it was not on the docket. Then apparently trove of new documents were filed on Friday. And I got here this morning not even having had this on my docket sheet. So I'm a little bit lost here. While we were on a short break between contested hearings, I tried to quickly scan through some of the documents, and what I was able to discern very quickly, and please, apparently, Mr. Partain, you are representing Ms. Wiles, who has, under the 2012 will, was the sole beneficiary. You're attempting to probate a copy of the will, which is non-conformed, and the two Hilton brothers, who I believe in one of your documents you say went into the decedent's home following his death and went through his personal effects.
Yes, Your Honor.
I've been unable to find the original of the will, and apparently somebody filed an application for a jury trial at some point, and everything's happened over the last couple of days as far as I can tell. So you want to start me out, Mr. Partain?
Your Honor, you have captured the essence of the alignment of the parties. This application to have a conformed copy of the will admitted to probate that was filed back on April the 19th of this year, Your Honor. I'm sorry, April the 19th is when Butch went into the hospital. He actually passed away on April the 30th. The application, Kathy's amended application, was filed on May the 19th. My mistake, May the 19th. And we filed in exchange. At that time, we received an opposition from the Hilton brothers. And that opposition was filed, that was filed on June the 11th. After receiving the opposition, we did initial disclosures, and what I received back from the Hilton brothers counsel was that they had no documents to substantiate any of the allegations or the opposition they were making. And the opposition, Your Honor, is not a contest. They're not asserting that the decedent lacked testamentary capacity or that the will was not prepared in a proper format or manner. What we're dealing with is a lost will. And we're ready to go forward with the evidence that I'm sure the court's familiar with under the state's code for proving up a lost will. And so we filed, after receiving their their responses to the initial required disclosure where they say they have no documents. We asked for the court to place this on its contested hearing. We filed the notice on August the 31st, and the notice of hearing went out. And then it was on Thursday, we get a demand for a jury from the Hilton parties. And then back on the 23rd of August, on the 23rd of December, we had an opposition filed by Andrea Rhodes, who is the
September?
sister. Yes, it was on September the 23rd, Your Honor, that Andrea Rhodes filed an opposition. And at that point, Your Honor, this hearing had been already scheduled. We had it placed on the docket, and the notice of hearing went out on August the 31st. With regard to the issues that we're dealing with here, the courts dealt with these types of issues before, particularly with the impact to our area for Harvey and Imelda. We're ready to present evidence today to prove up the lost will. And we've got Mr. Quigley here to testify about what was prepared and signed and executed by the decedent on June the 12th of 2012. We have Ms. Lombardo here, subpoenaed her. She's a representative, has worked for Edward Jones, and she is going to testify about her communications with Mr. Caldwell, the decedent, in efforts to get a will prepared, and actually a will was prepared. We also have Mr. Wilcox here today with us. He's here in the meeting room with me. And Mr. Wilcox was the longtime neighbor of Mr. Caldwell. And we'll talk about the Hilton brothers' access to the home during the period between April the 19th, when Mr. Caldwell went to the hospital, and April the 30th, when Mr. Caldwell passed away. So we have all of that information. We also have Kathy Wiles here, Your Honor, who's the applicant to be appointed as the independent administrator. Again, belatedly, we received the request for a jury trial. Again, we don't see any jury issues here. We also filed a motion to strike it because it's not timely. And then we get this motion for continuance, and the continuance, they talk about all this discovery they want to conduct. But to this point, the Hilton brothers have not identified any documents in their required initial disclosures. And they've also, in their motion for continuance, not identified what the discovery is that they want to accomplish. And again, Rule 252 is very specific about setting out the grounds for a continuance. You set out what discovery is needed, why it's material, and what it's going to prove once you get to that point. So those are, again, deficiencies with that. So we are, we oppose the continuance. This case has been, again, the application has been pending since May the 19th. I know the court's docket, unlike Houston, where you'll spend, years trying to get to a case, this court's very efficient, and you move your docket along, and we have that opportunity to do that. And we want to move forward with this hearing today, Your Honor. Court's pleasure.
Okay, let me tell you what I'm going to do, ladies and gentlemen, is I'm going to, you have witnesses here today. I'm going to take your testimony from Mr. Quigley, the applicant, Ms. Lombardo, and anyone else you wish to bring forward. And then we'll get to the probably give the parties an opportunity to brief the issue of the presumption issue related to revocation of the will, but let's go ahead and start with the testimony. So Mr. Partain, call your first witness.
Your Honor, may I respond just a moment?
Waters, go right ahead.
we would object to, Your Honor, this is a will contest. Under 55.01, this is a will contest, and we are entitled to a trial on the merits. At this point, we haven't had 45 days notice of a trial. These witnesses are basically a trial by ambush. We haven't had time to the required notice to prepare for these witnesses, for cross-examination of these witnesses. And I mean, it's just, this should be, and Your Honor, also, we contacted the court Friday, and we were told that there was no hearing.
Does anybody?
It had been, in fact, been moved until November 2nd. I'm sorry?
Does anyone know who it was that called this court and said it was canceled?
I have no idea.
Not me, Your Honor.
We were told it was moved to November 2nd. So at that point, we decided it was moved to November 2nd, stopped, we thought that sounded normal since we haven't had 45 days notice of any setting anyway. And we stopped, doing this. Also, with the objection to our jury trial, to a jury, they admitted it's a trial. And, at this point with the witnesses, the jury would not get to hear the witnesses. Say
that again?
Sure. We have asked for a jury trial, Your Honor. They objected to timeliness. However, we haven't even had 45 days of notice of a trial in any event. So I just object to having the witness testimony. We haven't had an opportunity to prepare for it, for cross-examination, and we ask that all this be moved to a trial docket.
Okay, I'm going to go ahead and allow Mr. Partain to adduce some testimony. However, one of the other issues that's going to have to be briefed by the attorneys is that 55.001 issue. So the court's not going to make a decision today, but I'll allow you, Mr. Partain, to decide whether you want to move forward with your witnesses or whether you want to and I apologize, I don't know who it was that called this court and said that the parties had agreed that this would be passed. But my clerks were advised of such, and so the court had not read everything prior to Friday, as would have been the practice. Of course, the jury demand wasn't filed until the 30th. But you still have the issue. I mean, there's too many issues here for me to make a decision today because you still have the issue of the 45-day notice of hearing. And I'm unsure of what notice was given them as we sit here. I haven't thumbed through everything.
Your Honor, we were provided notice of this hearing on August 31st.
And Your Honor, I don't want to, if I can kind of share Andrea Rhodes' perspective on all this also. She's the other contestant in the case.
Please proceed, Mr. Armstrong.
Sure. We're local counsel. Andrea Rhodes is she's a resident of Alabama. We were brought in here pretty recently, retained as local counsel recently. We filed our notice of opposition to the application, I guess a week and a half ago. We are just getting into this case. We don't know really much about the factual background of the case, and we certainly haven't had any opportunity to conduct any discovery in the case. We haven't reviewed or haven't had any serious opportunity to review the documents that have been produced. We were able to get copies of the disclosures and the document production that the applicant responded to. But again, we haven't been able to explore or investigate any of those claims or any of our defenses to the application here. Andrea Rhodes, she was served, and they, in the applicant's response to our motion for continuance, she was served with a waiver of service in June of this year. At that time, she wasn't represented by counsel. She signed the waiver, not really knowing what she was signing. Since that, I mean, she basically trusted Miss Wiles as her sister. Since that time, I mean, she's come to see that that there's real issues that need to be addressed here with the application to probate. She's gotten counsel, she's retained counsel. There was some delay in that because I think my understanding, Your Honor, is that she originally reached out to counsel for the Hiltons, and there was some question about whether or not there could be a joint representation. There ended up not being, or they ended up deciding that there couldn't be because of potential conflicts of interest. So she was casting about for a while, just trying to find an attorney. Until it wasn't until this past month in September that we got roped in as local counsel. So again, Your Honor, I mean, we really haven't had, I mean, we're obviously not in a position where, if the court takes testimony, we're not in a position where we can cross-examine anybody. We can't, we really aren't in a position to know what's being asked or what the subject matter of the testimony is. Considering the fact that the court hasn't had an opportunity to review the materials, that we haven't had an opportunity, Ms. Rhodes hasn't had an opportunity to review the materials, we've had no opportunity to prepare for the hearing today. It just makes sense that we, at a minimum, postpone the hearing just to give us an opportunity to get our bearings before we start taking testimony.
Well, I guess the court's concern here is that, if we had the original of the will here, y'all probably wouldn't be here. And I don't know whether or not these bald allegations of lack of testamentary capacity or undue influence have any evidence or to support them at all, especially since there have been responses to disclosure that have indicated that there apparently are none. And, that the impression that it leaves initially, and I hadn't heard all the evidence, is that you just don't like what happened in the will.
Well, Your Honor, and you pointed this out too. Like you say, Your Honor, there is no will. There's not even a copy of a signed will in this case. We just have copies of unsigned documents that they're trying to probate. And I mean, given the circumstances, I'm not a probate lawyer, but I've come to understand in the few days that I've had to review the materials, there's a presumption in this case that the will was revoked, and that's going to be their burden to prove. And again, this is something that's their burden that we haven't had an opportunity to conduct any kind of investigation on to see what other testimony there is out there. We don't know what they're going to say today. We don't know what the witnesses are going to say today, and we've got no ability to cross-examine them or really know what's going on at all, Your Honor. Your Honor, you can look at their pleadings. They've alleged several different grounds here for as the reason for to prove up the will, why it wasn't revoked. They're saying on the one hand that with the storms and everything that it was damaged and that it was kept in his personal, or as I'm understanding what they've alleged, that it was the document was kept with the decedent's personal papers that was destroyed in the hurricanes and storms that came through. At another point in the case, they alleged that it was, and I still don't really understand what this is, but they said it was kept in a lockbox or in some type of storage at a local bank. And then when that bank underwent some type of restructuring, it got lost somehow. In addition to that, they're also alleging that the Hiltons came, like you mentioned earlier,
closed down a lot of their operations here and apparently did away with their trust department, apparently shut down there.
Yeah. So, I mean, there are three different stories going on about what happened to this will. I mean, that, in my mind, Your Honor, that alone gives some basis for where we shouldn't go ahead with testimony. We should be allowed to, conduct some initial discovery, which we have not had any opportunity to do in this case.
Judge, I'd also like to add something when you have a moment.
Who was that?
That was me. I also like to add that there are deficiencies with the application as well that would affect, I believe, the court's ability to even hear the application at this time under 258.03. I don't believe that everyone has been cited. All of the errors have been provided citation.
For your honor, again,
Waters, I didn't hear you, Mr. Waters. Can you look at your computer when you're speaking, please? Because when you're looking away and reading, I have a difficult time understanding you.
Sure. Under 258.003, Your Honor, I don't believe the plaintiff, they have provided the errors with citation, proper citation, in order to allow the court to go forward at this time.
Your Honor, my response to that, we attached as an exhibit to our opposition to the notice to the motion for continuance, we attached as Exhibit A the Paul and Philip Hilton's initial required disclosure responses. And if the court will look at, it's on page 3, the legal theories and in general, the factual basis of responding parties' claims and defenses. There's nothing mentioned in that response regarding any type of deficiency of notice. There's nothing in this with regard to any type of lack of testamentary capacity or unsound mind or undue influence. Again, purely it's a statement just about the presumption with regard to revocation and the fact that we can overcome that with evidence. And that's what we're here to do today.
And we've had the thing that I would add, Your Honor, is we've had no opportunity. We haven't been privy to any of this evidence. We haven't been able to speak to any of their witnesses, namely Ms. Wiles. We haven't had, this really is trial by ambush. And certainly from our perspective, we've only been in the case for less than 2 weeks, Your Honor. We haven't, we haven't had an opportunity to look at any of this stuff.
Well, that's kind of you have had an opportunity because your client was served with a document several months ago and had an opportunity to discuss it with a lawyer then and apparently chose not to.
Well,
until later.
Your Honor, she did. She reached out. Well, she reached out to an attorney. Part of the reason for the delay, again, as I'm understanding it, is that there was some question about whether or not there was going to be the Hilton's attorney could undertake a joint representation. And I mean, that wasn't resolved until, again, my understanding is sometime in August. And then after that, it was, trying to be, she's not an attorney herself. She's not piped into this community. I mean, again, she truly was casting about trying to find someone who knew, again, and, she's in Alabama, Your Honor. She's trying to find a probate attorney in Alabama who knows someone in Texas that he can refer, a probate attorney in Texas that he can refer to. So, I mean, she's been bounced around between a lot of different people.
Mr. Partain, what's your response to their argument about the 45-day notice?
Well, Your Honor, again, this is not a trial. It's not been placed on this court's trial docket. Again, the court's procedures are very specific if you're going to have a case set for trial. This is a hearing to have a will, the lost will, to overcome the presumption. And again, it's not a trial. It's an issue that the court deals with on a daily basis. So again, it's not anything foreign to what your other contested matters that you have on your contested docket on a weekly basis. Again, I will profess to be a probate specialist and aware of what's going on. And I know in probate proceedings, you have little mini trials all along, and they're called hearings. And they take up different issues all along the way. And again, there's not any hindrance at this point for us to not go forward today. This belated assertion that, well, we need 45 days notice. Again, that's just what it is, Your Honor. It's a belated assertion. It's not any base for that.
I guess here's the next question under 55.001. If I decide today, if I hear testimony today and decide today to admit the will to probate, have I decided an issue thereby effectively precluding them from further contest?
No, Your Honor. The court is aware of, again, you can file a will contest for several years after it's been admitted. Again, at this point, this estate does not have a representative, and we are in a need of doing that. And again, our application, as I stated earlier, was filed, amended application was filed on May the 19th of 2021. And again, we need to move forward with this.
What is Mr. Hines' involvement? He's on the docket sheet.
I have no awareness of Mr. Hines in this case, Your Honor.
Anybody, Mr. Armstrong, Mr. Waters, y'all know anything about Josh Hines being involved in this case?
That doesn't sound.
Not that I can think of.
That doesn't sound familiar to me, Your Honor. There may be a Jerry Spiegel. He's the attorney in Alabama who Miss Rhodes originally hired, and he referred her to us to act as local counsel. I guess it's possible that Mr. Hines is someone in his office, but I haven't heard that name before.
No, Mr. Hines is a lawyer in Beaumont.
Okay. And Your Honor, if I could, the other thing I would add is there really is no prejudice to anyone in continuing the hearing from today. There's been no suggested that there's any issue with the assets that makes them likely to be depleted. I mean, this case has only been on file since May. I understand that courts move differently in Jefferson County than they do, and I respect the efficiency of this court's docket and its wanting to move things forward. But again, Your Honor, considering that one of the contestants has only been in the case for less than 2 weeks, I can't see any prejudice to any party from continuing the hearing on this probate matter until we've had a chance to, even a short continuance, to conduct depositions and for Miss Rhodes to conduct some discovery.
Who has access to the decedent's home? I mean, that's what I'm concerned about this. Who's paying his bills, his electrical bills? Who's
My client has been doing that, Your Honor. Mr. Wilcox had a key that was provided to him by the decedent. And again, the home is secure at this point. Yes. And he's present with me today if the court wants to talk with him. But I do intend to call him as a witness if we're allowed to go forward.
Okay. The court is going to allow you to do some testimony from your witnesses, but it's highly likely that the court is also going to allow the other party some leniency with respect to their contests and their opportunity to conduct discovery, given that I'm gonna have to have time to look through all these various provisions of the estates code, but I will allow you to call your witnesses. So call your first witness and I'll allow you to make your proof and hopefully, but this probably is not going to preclude further investigation by the other parties into the circumstances surrounding the will and its validity.
Thank you, Your Honor. Your Honor, at this time, the applicant would call Mr. John Quigley.
Waive the oath of an officer of the court. Did Mr. Armstrong, Mr. Waters, do you have any objections to that?
We would object that we're, we would incorporate our earlier objections to, based on the hearing going forward without us having an opportunity, without proper notice and without us having an opportunity to conduct discovery. We'll just incorporate our, and repeat by reference the objections raised in our brief. Otherwise,
okay.
none from us at this time.
The court is going to take advisement and not make a decision today. But the request for an objection was whether or not you had an objection to me waiving the oath for Mr. Quigley.
I'm sorry, I misunderstood, Your Honor.
I'll tell you what, let me just dispense with the necessity of that. Mr. Quigley, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth to help you God?
I do.
Okay, go right ahead, Mr. Partain.
Your Honor, do we have a court reporter with us?
No. We did not. We didn't have a request. We did not have a request for a reporter.
Right.
It's live on YouTube and it's recorded.
All right, that's perfectly fine, Your Honor. Thank you. All right, Mr. Quigley, state your name for the record, please.
John Quigley.
And what is your occupation, sir?
I'm a lawyer.
And how long have you been a lawyer?
49 years.
Okay. Are you familiar with an individual by the name of Joel P. Caldwell?
Yes, I am.
How are you familiar with Mr. Caldwell?
Mr. Caldwell approached me in 2012 about preparing a will for him. I met with him and sent him a draft of a will, and he came in the very next day and signed it.
Okay. Let me, we're going to share the screen here. Okay. Your Honor, may I, it says the host is disabled participant screen sharing. I was going to try to pull up my exhibit if the court would allow me to.
How to do that? It should be up at the top. Allow him to share a screen. This is why I typically want all these contested hearings held in court as opposed to by Zoom.
Your Honor, we asked for that opportunity and were directed to do it this way. So I'm all right.
Okay.
Thank you, Your Honor.
That's something. Well, you'll know Mr. Partain and the other participants in contested hearings. I want the people here in person in the future.
Thank you, Your Honor.
And Your Honor, I'm gonna, I don't want to unnecessarily delay things, but just to satisfy my own concern, I'm going to object to there not being a court reporter present. I understand that we're on Zoom right now, but I'm going to go ahead and throw out our request that we actually, on behalf of Ms. Rhodes, I'm going to ask that a court reporter, that this hearing be transcribed with a court reporter rather than just being recorded by Zoom. And to the extent the court wants to go forward without a court reporter, I just want to preserve our objection to that. Just to be on the safe side.
Objection is noted and overruled, and but it's on the record, and I don't.
Your Honor, we'll join in the objection, please.
So noted.
Your Honor, I'm trying, it's coming up with a notice here, host disabled participant screen sharing. And I'm trying to have the opportunity to pull up my exhibits that we filed last week. So.
Here it is.
What happened to my mouse?
Where's his mouse? Oh.
Okay, go ahead.
All right. All right. Mr. Quigley, I'm directing you to Exhibit 2. Can the court see Exhibit 2?
No, I cannot.
Yes, share.
You have to share your screen.
I thought I was doing that. Okay.
There it goes.
And
There it goes.
Your Honor, I apologize. I'm a little bit out to sea here, so I'm not sure exactly how things are handled, you know, in probate hearings like this. But I mean, to the extent before we start showing at the court, I'll object to authentication, and I ask that we move to admit the exhibit before it's presented into the record.
Well, I have to get it first identified, and I just wanted to make sure people could see it.
Sure, sure.
That's what I was trying. Okay.
Okay.
All right. Yeah. Mr. Quigley, I've handed you what has been marked as exhibit number 2 and ask if you can identify this document.
That's the cover letter I used to send Mr. Caldwell's will to me.
Okay. And the documents that are collectively with Wiles, starting at exhibit 2, it starts at the bottom, Wiles 25, and goes through Wiles 115. Can you identify for the court what those documents are that were included with your letter?
The will and the power of attorney that I wrote for him.
Okay. And these are true and correct copies that were taken from your file. Is that correct?
That's correct.
Okay. Your Honor, at this time, I would move for the admission of applicant's exhibit number 2.
Any objections?
Not from Ms. Rhodes, Your Honor.
Mr. Waters?
None other than the previously asserted objections, Your Honor. No.
All right, to be admitted.
Thank you. Your Honor, let's go to exhibit number 4. And Mr. Quigley, I'm showing you what has now been marked as applicant exhibit number 4. Can you identify this document, sir?
Yes, that's Mr. Caldwell's last will and testament.
Okay. Looking at this particular document that goes through, this is exhibit 4, goes through Wiles 005, is that correct?
That's correct.
Okay. And this particular document, is it a true and correct copy of the original?
Yes, it is.
Did Mr. Caldwell sign this document in your presence?
Yes, he did.
At the time Mr. Caldwell signed this document, was he over the age of 18?
He was.
Did you have 2 witnesses also present when Mr. Caldwell signed this particular document?
Yes, I did.
And were both of the witnesses over the age of 14?
They were.
And with regard to this particular will, you are also board certified in estate planning, is that correct?
That's correct.
Did you satisfy yourself that Mr. Caldwell had the requisite mental capacity and testamentary intent to execute this document that we have before you as exhibit number 4?
Yes, I did.
Your Honor, at this time, we would move for the admission of applicant's exhibit number 4.
Any objections?
I'll object to the extent that this is not a copy of the will. This is a draft document that's unsigned. And we would object to its admission as a, as a fair and accurate representation of the will itself. This isn't a will. This is just a draft document, an unsigned draft document.
Okay. Mr. Partame, I tend to agree with Mr. Armstrong, given the fact you asked Mr. Quigley if he signed this document. And obviously, he did not sign that document. He may have signed one identical to that document, so I ask you to clear that up for the court, please.
Thank you. Mr. Quigley, you've looked at the document that has been marked as exhibit number 4, is that correct?
Yes, that's right.
And is this document identical to the document that Mr. Joel Caldwell executed and signed in your presence on July the 12th of 2012?
Yes, it's identical.
Your Honor, with that clarification, it has the S signature on there. Who placed that on there?
Sandra Smith.
Okay, and is Ms. Smith with us today?
She is.
Okay. And is that the practice when a document is signed in your office for her to make that notation on the conformed copy?
Yes, the S stands for signed, and she applies that after the client signs the document.
The other name that is written there, John Quigley, were you the notary of this particular document?
I was.
Okay. And did Mr. Caldwell sign an identical document to Exhibit 4 in your presence, and you notarized his signature?
That's correct.
And this was done on July the 12th of 2012, is that correct?
That's right.
Your Honor, at this time, I would move for the admission of Exhibit number 4.
Any objection?
None from Ms. Rhodes, Your Honor.
It will be admitted.
Thank you.
Your Honor, I'll object to the speculation portion of what Ms. Smith did. I didn't understand that he witnessed that. I don't think that it's within his personal knowledge.
Well, we have Ms. Smith here, Your Honor, and she'll testify about what she did, but factually, she did it in Mr. Quigley's presence. So that's.
And also, it's not represented in the list of fees presented. Doesn't reflect that as well. But so okay, but I do object to the admission, Your Honor. I believe that.
Overruled. It'll be admitted.
Thank you. Mr. Quigley, directing your attention to exhibit number 5, do you recognize that document?
I do.
What is that document?
That's the invoice that I sent to Mr. Caldwell after he signed his will.
All right, and the date of the invoice is what?
August 1st, 2012.
All right, and this is a true and correct copy of a document or of the invoice to Mr. Caldwell that are prepared at our law office. Is that correct?
That's right.
And this is done as a part of the regular course of business?
That's right.
And is it made by someone with knowledge of personal facts at or near the time reflected on this particular document?
Yes, it is.
Are you the custodian of this particular record?
Yes, sir.
And the entries that are made on this particular record, are those compiled from your daily timesheets with regard to the work and the legal services you perform?
That's right.
All right. Your Honor, at this time, I would offer exhibit number 5.
Any objection?
None from Ms. Rhodes, Your Honor. However, I would like a running objection based on the fact that we haven't had an opportunity to review any of the documents that are being presented to the court today. To the extent my earlier objection to the record and so forth didn't include that, I would like a running objection just to the fact that we haven't had an opportunity to review any of the documents that are being presented today or witnesses.
We'll give you that objection, running objection.
Your Honor, would also like a Your Honor, we would also like a running objection based on the previous objections asserted as well.
Granted.
Your Honor, I will point out that our exhibit list, along with the exhibits, was filed last week. And it was also supplemented on Friday to include the documents from Edward Jones, which Ms. Lombardo will talk about shortly. So they've had these documents in their possession through the witness list that was served through the eServe system. So.
Your Honor, to the extent that that would, there's some sort of argument that dismisses our arguments against this that we made in the contest. I mean, that would have to be the subject of a summary judgment motion or some other, I'm not sure what procedural mechanism they're attempting to utilize to dismiss all of our the grounds for our opposition. However, these items were certainly not on file for the requisite amount of time to defeat to be used in a summary judgment hearing, if that's what they're doing. And also, if that is the mechanism, oral testimony is not admitted. It should not be presented in a summary judgment hearing. I just think the entire process is objectionable.
Okay, I would note, Mr. Partain, that those exhibits and everything did not come in until Friday.
E-filed on the 30th, but they didn't come through on the
Shows that,
system.
so they were apparently e-filed on the 30th, but didn't come through the system
Until October 1st.
until October 1st. Of course, that was 1 day difference, but just out of curiosity, what percentage of the value of Mr. Caldwell's estate is in his Edward Jones account?
Your Honor, the non-probate assets at this point, I think include a house, and we're, again, one of the reasons for having a representative is to have communications with Prudential Life Insurance and some other, I think there's another life insurance policy that's outstanding also. So other than the house, a truck, and there's also a bank account with BBVA and perhaps Capital One also that has those, we don't know yet whether those are payable on death to a particular person or whether they were payable to his estate.
Okay, but it appears, I mean, it appears the Edward Jones account is a non-probate asset. Is that?
That's correct. And the transfer on death beneficiary was Kathy Wiles, and that's been accomplished.
Okay. All right, that was an aside. So I've noted the running objections and admitted the exhibit number 5.
Okay. All right, Mr. Quigley, did Mr. Caldwell ever contact you after July 12th of 2012 and tell you that he wanted to change his will?
No, he did not.
Did Mr. Caldwell ever call you and tell you or inform you in any way that he was dissatisfied with Kathy Wiles?
No, he did not.
With regard to the communications you had with Mr. Caldwell, there's a statement in the amended application here about a safe deposit box at Capital One. Are you familiar with that particular statement?
Yes.
Can you tell the court the basis for including that in this amended application?
I was speculating, I'm afraid, about what could have happened to his will, and obviously I did not know, but I knew that Capital One had closed all of its safe deposit boxes in Beaumont, and so one theory was that he had been forced to remove his will from the safe deposit box, and perhaps it had gotten misplaced as a result of that.
All right. Okay. And you filed the amended application on behalf of Kathy Wiles, is that correct?
That's correct.
Do you know of any reason that Kathy Wiles is disqualified to serve as an independent executrix of this particular state?
No, I do not.
Your Honor, this is all the questions I have for Mr. Quigley. I'll pass the witness at this time.
Any questions, Mr. Waters or Mr. Armstrong?
I'm sorry, Judge.
Not at
What
this
was-
time.
was
Not at
the-
this time. Not at this time, Your Honor, reserving our right to cross-examine the witness after we've been able to conduct discovery.
Thank you. All right.
Yes, I apologize.
Your Honor. Your
Was the
Honor.
Your Honor, I was also discussing, we're talking about the application. Was it admitted to probate? Excuse me, was it admitted as into evidence? The application, amended application?
Exhibits 2, 4, and 5 were admitted into evidence.
Okay. And not 7. Okay.
Your Honor, at this time, I will call Sandra Smith.
All right, Ms. Smith, if you raise your right hand. You solemnly swear or affirm the testimony you're about to give in this cause should be the true self you got.
And Ms. Smith, state your name for the record, please.
Sandra Smith.
And what is your position?
I'm the legal assistant to John Quigley.
You have to talk a little louder.
Legal assistant to John Quigley.
And in that particular position, are you familiar with this document that I have placed before you and the court's admitted into evidence as exhibit number 4?
Yes, sir.
All right. How are you familiar with this particular document?
I prepared it.
All right. And is your, on page 2, do you see the S on that particular document?
Yes, sir.
And going on to page 3, or did you place the S on those particular pages also?
Yes, sir.
And looking at page 4, are there also those particular S's?
Yes, sir.
Can you tell the court why you did that?
This is a conformed copy, and this has been my standard practice for 31 years.
Right? The document, why do you prepare, or you said it was a conformed copy. What is this practice? When do you do this?
It shows who was, that the testator was in that day, shows the day, it shows who the witnesses were that day, and who the notary was.
Okay. And was this particular, an identical copy of this particular document prepared and signed by Mr. Caldwell on July the 12th of 2012?
Yes, sir.
Okay. And with regard to the witnesses, were you and Ms. McClanahan, you're both over the age of 14, is that correct?
Yes, sir.
And Mr. Caldwell signed this, a document, the original of his will, in your presence, is that correct?
Yes, sir.
And the original of the will was that given to Mr. Caldwell?
Yes, sir.
All right. And after, as a part of our practice here, did you retain this conformed copy?
Yes, sir.
Did you satisfy yourself that Mr. Caldwell had the mental capacity to sign this particular document when you witnessed it in your presence?
Yes.
Objection, speculation, calls for speculation.
Did Mr. Quigley, well, you've witnessed several wills, have you not?
Yes, sir.
Okay. And the preparation of this will, you said you did this yourself, is that correct?
Correct.
And Mr. Caldwell came into the office and signed it in your presence, is that correct?
Yes, sir.
Did Mr. Quigley communicate with Mr. Caldwell prior to him signing this particular will?
Yes, sir.
Based on that communication, did you form an opinion of Mr. Caldwell's mental capacity to execute this particular document?
Yes.
Objection, speculation, and calls for expert conclusion or expert opinion testimony.
That's all right.
You've been, it's not required as an expert to be a witness to a will. So let me ask you this, Ms. Smith, the document that we have in front of you, Is this an identical copy of the original that was signed by Mr. Joel Caldwell?
Yes, sir.
To your knowledge, did Mr. Caldwell ever call the office and make an appointment or communicate with Mr. Quigley at some point after this date and tell you that he wanted to change or make any changes to this particular will?
No, sir, he never called.
All right. John, this time I'll pass the witness.
You wish to reserve for the future as you did earlier, or do you have any questions for this witness, gentlemen?
Yes, Your Honor, or no, Your Honor, we'll reserve all right to re-question this witness or reopen testimony after we've had a chance to conduct discovery.
Your Honor, I do have a couple of questions, but I don't want to waive my right to ask additional questions at a later time.
Court will allow you to ask a question without prejudice to further questions.
Thank you, Your Honor. Ma'am, how long, Mr. Quigley was the attorney that spoke with the decedent, is that right?
Yes, sir.
And how long did he speak with the decedent?
I don't know. It's on the timesheet.
That you just don't recall, or do you recall the questions that he asked?
I was not present.
Talking about the will signing.
The will signing. Oh. So what was the question again?
Sure. Were you, let me ask you this way. Were you present when Mr. Quigley talked to the decedent on the date of the will signing?
Yes, sir.
And how long did he speak with the decedent?
That day?
Yes, ma'am.
15 minutes. It doesn't take long.
Were you present for that conversation?
Yes, sir.
Were you present for, did Mr. Quigley also speak with the decedent outside of your presence?
Yes, sir.
And how long did that occur?
It was within that time frame.
So how much of that time frame were you present for the conversation?
I was called in for the signing of the will.
And how long does that take?
5 minutes.
Okay, thank you. I'll reserve the rest of my questions. Thank you.
Thank you.
All right. Nothing further from this witness, Your Honor. At this time, I would call Mr. Leon Wilcox.
Mr. Partain, Ms. Lombardo has been in attendance by video for a long period of time.
Yes.
There's some reason you can't take her so that she can be excused?
Yes, sir. You're correct, Your Honor. I'll do that right now. Let me take Ms. Lombardo. It's my next witness, and I apologize.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call shall be the truth, so help you God?
I do.
State your name for the record, please.
Tina Lombardo.
Ms. Lombardo, what is your occupation or profession?
I'm a financial advisor.
And who are you employed by?
Edward Jones.
And how long have you been with Edward Jones?
26 years.
Okay. And how do you know Joel P. Caldwell?
He was referred by a CPA in town back in, I believe, 08.
And as a part of that, did you also learn that Mr. Caldwell goes by a nickname?
Butch.
Okay. When you were communicating with Butch, did you use Butch or did you use Mr. or Joel Caldwell?
I always called him Joel.
Okay. All right. Let me ask you, as a part of Edward Jones, you were subpoenaed to be here today. Is that correct?
Yes.
And as a part of that, you were asked to produce certain documents, and you have been cooperative and produced those documents. Is that correct?
That's correct.
Let me ask you to look at Mr. Caldwell made a decision with regard to how he wanted to have his Edward Jones account handled. Is that correct?
Yes, he did.
And did he give instructions to Edward Jones with regard to that particular account?
Yes, he did.
Okay, I'm looking at Exhibit 18. Exhibit 18 are the documents that were produced by Edward Jones. Are you familiar with those documents, and are they part of the business records of Edward Jones with regard to Mr. Caldwell?
Yes, I do recognize them, and yes, they are part of our records.
Okay, and these were produced in response to the subpoena, is that correct?
Yes, they are.
Okay, I'm looking at Exhibit 18. Well, Your Honor, at this time, we would offer Exhibit 18, which are the Edward Jones documents.
Any objections?
None other than our running objection, Your Honor.
Same, Your Honor.
It will be admitted.
All right, thank you, Your Honor. Looking, Ms. Lombardo, at the screen here, I have, I'm back in the Edward Jones documents, 00059 is the page number. And I'm going to go to the next page and ask you if you can identify what that document is.
It's a transfer on death document that designates beneficiaries on his accounts.
And the date for that document is what?
May the 10th of 2011.
All right. And going to the 3 pages back from that, did Mr. Caldwell sign that document?
Yes, he did.
And did Mr. Caldwell identify who he wanted his Edward Jones account to go to?
Yes, he did.
And who did he identify?
Kathy Wills.
Okay. And she's identified on this particular document. Is that correct?
That's correct.
All right. And then the date of that document was May the 10th of 2011. Is that correct?
That's correct.
Was this document ever withdrawn or changed by Mr. Caldwell at any time prior to his death on April the 30th of 2021?
No, it was not.
Okay. Did you meet with Mr. Caldwell on a regular basis?
Yes, I did.
Tell the court about how frequently you would meet and the purpose of your meetings.
We would have a meeting at least once a year, maybe more than that. And the meeting was to go over investments, go over his risk tolerance. And then we have a standard operating procedure to go over if they have life insurance, wills, power of attorneys, things like that.
Okay. And did you make the inquiry with Mr. Caldwell about whether or not he had a will?
Yes, I did.
Okay, I'm getting to it here slowly. Sorry about that.
That's okay.
I'm going to get to page 41. And these are, they're identified as relationship activities and notes. Do you see that, Ms. Lombardo?
Yes, I do. Yes, I do.
Okay. There is a statement on June the 20th of 2012. Do you see that particular?
I do.
Entry?
I do.
And there's regarding over in one of the columns is the word need, N-E-E-D. Do you see that?
Yes, I do.
And what was this entry and why was it made?
Your Honor, Your Honor, I'll object as hearsay within hearsay.
Sustained.
All right. Well, this is a business record that's already been admitted. Ms. Lombardo, this particular document, the relationship activities and notes, who makes those particular entries?
I do.
You made those, okay?
Yes.
How did you make those?
During the client's visit or right after he leaves, I document the conversation I had with the client. And this one stated that at that time he did not have a will, power of attorney.
Objection, Your Honor, hearsay within hearsay.
Overruled.
Thank you. All right. So the statement goes on there, getting with John Quigley. What is that statement about?
I use John.
Objection, Your Honor, hearsay within hearsay and calls for speculation.
Overruled.
You want me to continue?
Yes, ma'am, please. Thank you.
I use John Quigley quite frequently because so many of my clients do not have their estate planning in process. So we referred him to John Quigley to have something prepared for himself.
Okay, looking at the next page, which is Edward Jones 40, there's an entry in the September 14, 2012 timeframe. Is that correct?
Correct.
And tell the court who made that entry.
I made that entry with the TL that designates me, and that he got with John Quigley and had a will and a power of attorney done at that time.
All right.
What's wrong?
Okay, looking at, so this particular document, did Mr. Caldwell ever tell you at any time, Ms. Lombardo, that he had withdrawn his will or he had torn it up and discarded it?
No, he did not.
Objection calls for hearsay.
The question was whether or not he ever told her that?
Yes.
Okay. Overrule.
Okay. Now, Ms. Lombardo, you would meet with Mr. Caldwell. Again, these notes go on for several pages here. Was it your practice to meet with him on an annual basis or a regular basis? Is that correct?
At least annually, it's required by me.
And as a part of that, did you always make the inquiry about the status of his estate planning needs?
Well, once I knew that he had established a will and a power of attorney, then I didn't go into it any further. So,
right.
But I always, when I have reviews with my clients, I always go over beneficiaries to make sure that it's still their wishes.
Okay. And did Mr. Caldwell ever tell you at any time that it?
Let me interrupt you. We're going to take a 3-minute break and be right back.
Thank you.
Yeah, I'm gonna run my bathroom.
Bruce and Mr. Quigley, I didn't get a chance to tell y'all hello, and it's good to see y'all.
Good to see you, Travis.
And please tell Sandy I said hello too. I don't know if she's still there with you or not.
No, we had to put her back to work. She's our office manager now. Yeah.
Okay.
She actually just texted me, Travis, and she said, Travis used to work here. Tell him I said, hey, if you get a chance. So
okay.
Yeah.
We're trying to pinpoint the date. When was that, Travis? How long ago was that?
Pardon me? Oh, when I worked there, it was, I finished clerking with Judge Crone in 2011. So it would have been right after that. I would have started in the fall of 2011. And then I worked there until, I guess, the winter of 2012.
Yeah, that was my guesstimate. I didn't go back and pull your personnel records. We're still scrutinizing those, but
yeah.
No, it's again, it was I appreciate the time you spent with us, and particularly after working with Judge Crone and coming over with us for a short time. If I recall, your wife was a college instructor, and is she still teaching somewhere, or what's going on with that?
Yeah, she taught English at one of the Lamar sister campuses. I can't remember which one now. She still does that. She still teaches English at the San Jacinto Community College. We live in Pearland, and it's right down the road from us.
Okay, I know exactly where Pearland is. I can tell. Yeah,
you grew up in what?
I grew up in Lamar. Yeah.
Okay.
Yeah.
When I was when I was getting ready, when I left y'all's firm to come to Houston, Steph was a few months pregnant. And since then, our boy that she was pregnant with at the time is now 8 years old. And we've adopted a little girl since then.
Oh. Congratulations. Yeah.
Thank you very much.
Tina, are you still with us?
I'm here.
Okay. Well, thank you for bearing with us today.
That's okay. I have time blocked out most of the day, so no big deal.
Oh, no. Okay.
Yeah, that kind of happened to us. We tried 10 years to get pregnant. We adopted a son. A year and a half later, she gets pregnant.
Oh, that's a guarantee with
control.
Yeah. Yeah.
Okay, go right ahead, Mr. Partain.
Thank you, Your Honor. And just a few more questions for Mr.
Armstrong. What happened to Mr. Armstrong?
I don't know if he's still there. Can you hear him?
Can you hear me, Mr. Armstrong?
Hello. Muted and off video.
He's what?
He's muted and off video right now.
Okay, apparently Mr. Armstrong is muted and off video right now.
Okay.
He's still showing as being present. I'm not sure I gave him the full 3 minutes, so we'll give him a few seconds.
Sorry about that, Your Honor.
You got it? Okay, go ahead, Mr. Partain.
Thank you. Ms. Lombardo, I have pulled up in front of you a document that's labeled Edward Jones 00046. Do you see that document?
Yes, I do.
And this was a document, again, that was was in the Edward Jones file. Was that correct?
Yes, it is.
And tell the court what you understand this document to be.
It's a statutory durable power of attorney.
Okay. And did Mr. Caldwell provide this to you?
Yes, he did.
Okay. And there's also a medical power of attorney. Is that correct?
Yes, there is.
Okay. And who does he identify here as the agent under the medical power of attorney?
Kathy Wills.
And we go back to the statutory durable power of attorney. And does he identify who his agent is here, or who the attorney
Yes.
in fact is? Okay.
Kathy Wills. Yeah, Kathy Wills.
Okay, thank you. And we go forward to the medical power of attorney information, and then I come over to another form here that is this form. It's a power of attorney summary form, and it's found at Edward Jones 57. Do you see that document?
Yes, I do.
Okay, tell the court what this document is.
This document is a form that we use when we get a power of attorney. It's designating who the power of attorney is. We need to get their information, such as address, dates of birth, social security number, and contact information. And then it goes to our legal department for approval.
And this was, it has a date up in the right-hand corner of December 9 of 2014. Is that correct?
That's correct.
And it refers back to the original form executed July the 12th, 2012. Is that correct?
That's correct.
Okay. All right. And it's actually has signatures down at the bottom of the page, does it not?
That's correct.
Does that have Mr. Caldwell's signature?
Yes, it does.
And also Ms. Wiles' signature, is that correct?
Yes.
Was this document ever changed where he, Mr. Caldwell chose a different attorney in fact or agent?
No, it never was.
Okay. Okay, let me ask you to look at, and I'm looking at Exhibit 15. And it's marked Wiles 00138, and give you a moment and see if you can identify this particular document. It's dated August 21, 2019.
Okay, one moment.
Sure.
August 28th.
August 21, 2019.
Yes, it looks like it was a confirmation of an appointment.
All right. And it's, there's a statement here in the very first sentence. Do you see that particular statement?
Yes, I do.
And why do you include that statement?
Because we just always need to make sure during every appointment that we're on track, the information that we have on their accounts are accurate, and what their plans are with the money, and that we have our goals and everything updated at all times.
Okay. And the Exhibit 15 that I'm asking you to look at, again, these are documents from the Edward Jones file. Is that correct?
Yes.
Okay. And even his account statement here
Yes.
with that. Okay. Your Honor, at this time, I would move for the admission of Exhibit 15, applicant's Exhibit 15.
Any objection?
None other than our running objection from earlier, Your Honor.
Your Honor, on page 150, there are quite a bit of handwritten notes. I don't believe that would be a true and correct copy of that document.
150?
150.
Are you talking about the bait stamp number?
Yes, Your Honor. It says Wiles 150.
That's mine, not.
Do you know whose writing that is on that page? Mr. Partain or Mr. Lombardo?
It's not mine, and it's not any of my staff's.
Your Honor, I think I can prove it up with Ms. Wiles.
Yes.
Okay, that exhibit, with the exception of bait stamp page 150, will be admitted.
Thank you, Your Honor. Your Honor, that concludes the questions I have from Ms. Lombardo, and I thank her for her attendance today.
Can I ask to be removed from the subpoena, or am I assuming that I'm still going to be under the subpoena?
Wait 1 second. Mr. Waters or Mr. Armstrong, do you have any questions of this witness at this time?
Not at this time, Your Honor. Will reserve our right to re-question this witness later.
Mr. Waters?
The same, Your Honor.
Okay. Mr. Partain, Ms. Lombardo, with respect to the subpoena?
Yes, I do, Your Honor.
All right, you may be excused, Ms. Lombardo.
Thank you so much.
You.
Bye-bye.
Have any other witnesses?
I do, Your Honor. Mr. Leon Wilcox is present, and he's seated here with me. And if the court would swear him in, please.
And Mr. Wilcox, you raise your right hand, please. You solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God.
Yes.
Okay, go right ahead, Mr. Partain.
Thank you, Your Honor. Mr. Wilcox, can you state your name for the record, please?
Sure, it's Marion Leon Wilcox.
And how do you know Mr. Butch
Do we
Caldwell?
still need to share our screen with you?
No. I can stop the share now, Your Honor.
Okay, very good. Thank you.
Okay. All right. Okay. Mr. Wilcox, you go by Leon, is that correct?
Yes, it is.
All right. Do you have any objection to me calling you Leon?
No, not at all.
Okay. All right. Leon, you knew Butch for many years, is that correct?
Yes.
Tell the court how you became acquainted with Butch Caldwell.
Well, I first met Butch, when he was working at a boat and nut fastener shop on College Street in Beaumont. I'd go by there, I work for General Electric plant, and have to pick up specialty boats, and that's how I met Butch originally. I didn't even know he was a neighbor of mine.
Okay. And you learned later that Butch was a neighbor of yours, is that correct?
Oh, yes.
And this is in the north end of Beaumont?
Yes, it is.
Okay. Butch is, and as a part of his routine, was his home nearby your home?
Yeah, 3 houses down.
Okay. And would you see Butch on a regular basis?
Every day.
Okay. Did you have occasion to sit on the porch and talk with Butch about life and things going on?
Pretty much maybe 3 times a week.
Okay. In those occasions, did you discuss Butch's family with him?
Butch brought it up himself, like he would be going to Alabama and he would ask me.
I'll object. I'll object to this line of testimony as hearsay, Your Honor.
Again, this is a present sense impression. The statements were made by the decedent to this individual. And
how do you get past the dead man statute?
well, you can corroborate it, Your Honor, because we've got other witnesses, particularly Ms. Wiles, who is from Alabama, and there were occasions where he would come and visit.
Okay, I'll tentatively allow it pending corroboration.
Okay, thank you, Your Honor.
Sir, if you don't want me to tell the truth.
No, don't. Sir. Okay, we'll work with this. Okay, all right. Leon, did Butch ever mention the name Kathy Wiles?
Yes.
How did Butch mention that name?
It was his cousin that lived in Alabama.
Okay. Did Butch ever mention?
I'm sorry, I don't want to break this up, but I just want to. Can we get a running objection to the hearsay with the understanding that it's been overruled, subject to the corroboration?
Yes, sir.
Thank you, Your Honor.
All right.
Same objection, Your Honor, and I'd also like to object that we're unable to cross-examine the witness in the same room as counsel here. The Zoom proceedings are not being applied equally to all parties here. I'd also like to add that objection.
Well, that's very interesting, Mr. Waters, given this COVID environment that we're in, and I would certainly prefer otherwise. I'll objections noted and it's overruled.
Okay. Did Butch ever mention anybody, any Texas relatives?
No.
Okay. So other than talking about Kathy and the Alabama relatives, Butch never mentioned anybody in Texas?
No.
Okay. And again, you were aware that, did your home sustain flooding in Hurricane Harvey in August of 2017?
Yes, it did.
Did Butch's home at 11435 Forest Glen in Beaumont sustain flooding during Hurricane Harvey?
Yes, it did.
Can you describe for the court the damage that Butch's home sustained?
Well, I think he had more water in his house than I had in mine. I'm on a higher lot. I'd say he had 5 to 6 foot of water in his house, and it pretty much destroyed everything that was below 6 foot.
Okay. And as a part of that, the impact of Hurricane Harvey, was Butch immediately back in the home, or was he away from that home for some time?
No, he had rented a townhome for quite a while, and it was quite a while before he got back into his home.
All right. Okay. The water damage that impacted the home during Hurricane Harvey, did you see the impact on the inside of the home?
Yes, I did.
And were there papers and documents that were saturated as a result of the water?
There was some, but not a whole lot.
Okay. The water on the inside of the house, did it require the sheetrock to be torn out?
Yes.
Okay. What about the floor? Did it have to be replaced also?
It was replaced.
Okay. And was the repairs to Butch's home, do you recall those starting in early 2019?
Yeah, I would say 19 because he waited quite a while before he ever got started on his house. Because he had that lease on the townhouse, and I think it was a year lease.
Okay. Now, you had occasion to visit in Butch's home to see how his personal papers were, how he would organize things. Is that correct?
Yes.
Did you consider Butch to be someone that kept his papers in good order?
Yes.
All right. Describe for the court why you make that statement.
Well, when I go over there, he had stacks of, I would say bills or whatever. They were stacked in order, I would guess. And he had totes.
Objection, Your Honor, to the extent this testimony includes speculation.
I mean, he's firsthand observation. I mean, that's what he's talking about. Go ahead.
Anyway, yeah, he was pretty well, you know, I don't know, I guess you'd say tidy with his stuff, you know, he kept it in order and everything.
Okay. Now, let me ask you to fast forward to April of 2021, particularly April the 19th of 2021. What do you recall about that particular day?
I think that's the day we went to check on Butch because I hadn't seen him in about 4 or 5 days, drive by.
Okay. So you were concerned about his well-being?
Yeah, health and welfare.
What did you understand some of the medical challenges that Butch had?
Well, I know he had diabetes real bad, and I think he had a heart problem also we talked about because I've got a heart problem.
Did you go to Butch's home on April the 19th?
I think I did, yes.
Okay. And did the police meet you there to do a wellness check?
Yes. We went down there and rang the doorbell and beat on the door and never got a response. So we called the police to do a health and welfare check, and they showed up, and we went around. I showed him where his bedroom was in the house, and we went to the backyard, and one police officer was beating on the wall with his flashlight, and a lady officer was kind of peeping down through the wood Venetian blinds, and she could see him laying on the floor moving his arms, so we knew he was in there. Okay. So that's when we went back around front, and rescue people broke in the door and tore it up pretty good.
All right.
And so he did not want to go to the hospital, and I told him I'd get on top of him and ride on him if he didn't go. So
all right. So was he taken by ambulance to Baptist Hospital?
Yes, he was.
Okay. And after that particular, did you have occasion to notice the damage to the front door?
Oh yeah, definitely.
Okay. And did you undertake to repair the front door?
I did.
All right. And on one of your occasions down checking on Butch's home after April the 19th, did you notice a note that was left on a particular vehicle?
I did. I was getting in Butch's truck and starting it every once in a while. We'd go down and feed his cats. And so one day I was setting the truck, started, and I seen a note underneath the windshield wiper. And I believe it, I can't remember if it was Paul or Philip's name on the phone number. And
Your Honor, I'll object to this testimony as hearsay.
Let me break it up for you.
Let me ask, is he just saying what he read on the paper?
Yeah.
Yes, sir.
Overrule.
Okay. And after seeing the note, did you call the telephone number?
I did call.
Okay. And did you talk with either Paul or Philip Hilton?
I did.
And what did you talk with them about?
I told him that Butch had been taken to the emergency room, and I did not know how to get a hold of Kathy, so I didn't know who they were. So I just told them that Butch was in a ICU at Baptist Hospital, in Beaumont.
And after having this telephone call, did they come to Beaumont after that? They being Paul or Philip?
Yeah, it was a little bit after that, and
Okay.
I also had gotten Kathy's phone number from her.
Okay. So after you talked with them, they came to Beaumont, and did you have a conversation with them?
I did.
Tell the court what you talked with Paul and Philip Hilton about.
Objection, Your Honor. This calls for hearsay.
Did you ask him what they actually said to each other?
Yes, he had a conversation
Are
with
you trying to
Paul.
prove the truth of the matter, sir? I haven't heard it yet, so I don't know.
Well, they're also a party, Your Honor, and as a party opponent, again, counsel can have his own client to either here to testify or whatever, but let me
Well,
ask
I
Mr.
don't know if it's an admission by a party opponent, so I don't know what you're getting at. I'll reserve my ruling until I hear what he has to say.
Okay. All right. Your conversation with either Paul or Philip, what did you talk about?
Well, they asked me if I had a key to the house, and I said I did.
Did you provide them a key?
I did provide them with a key.
Okay. And then what did you observe them going into the home?
I did.
And what time of day did Paul or Philip go into the home?
Oh God, I don't know. It was early afternoon, maybe.
Okay.
I don't know exactly what time it was.
Did you stay with them during the entire time they were there?
No.
All right. How long did you stay? And then
probably about 30 minutes, 35 minutes.
All right.
I told them that I'd found some money in Butch's, I call him Butch. So anyway, I found some money in his pants pocket, and I put it up in the top dresser drawer and closed the door and drawer. And then they stayed there for quite a while. I think that's the same day they spent the night, or they might have went home and come back and spent the night.
Okay. So they were there that afternoon or that day, and did they come back the next day?
I think they did.
All right. And can you give the court some estimate of how long they were in the house on both occasions?
Your Honor, I feel like with some of the testimonies, just speculation. It's lots of I think, or there's no definitive memory. It's just speculation, Your Honor.
Okay, sir, were you able to observe how long they were in the home? Approximately?
Yes, sir.
Okay, I'll overrule.
Approximately how long were they in the home?
Probably about two and a half hours.
Okay. That was on the first day?
Yes, sir.
What about on the second day?
They were there most of the day.
All right. So did they arrive mid-morning and stay till late afternoon?
Early morning.
Objection, Your Honor. The counsel's testifying.
Make sure
John, I'll withdraw it and ask it. How long were they in the house the second day?
Many hours. How about that?
Okay. All right. All right. And did you have occasion to go into the home after they left?
I did.
All right. Tell the court what you observed after you went into the home after Paul and Philip vacated the home.
I could tell that the house had been gone through. There was some magazines left out on the bed and stuff, and in the spare bedroom where he did all his bills and stuff, there was 4 totes on a table, and there was 2 totes left when I went back in.
Your Honor, this question is called for speculation. This is his testimony is speculation.
Oh,
Object.
Hey, totes?
Yes.
T-O-T-E-S?
Yes, sir. Clear white totes that had paperwork in them.
Okay.
And what was missing?
Your Honor, again, this is speculation. I'll object to this line of questioning as speculation.
All right.
He's just testifying to what he observed. Overruled.
Thank you. All right. Mr. Wilcox, go ahead. Tell the court what you observed when you came into Butch's home after Paul and Philip had left?
Well, I just said that I could tell the house had been gone through, and there were 2 plastic totes, maybe 2.5, 3 foot long, and maybe 26 inches wide with clear lids on top of the clear totes.
Right. And after you observed what the condition of the house, did you have a telephone call with Paul later?
Yes, I did.
All right. And did you have a conversation with Kathy Wiles and Paul at the same time?
Yes, I did.
Okay.
Yeah, Your Honor, I want to be lenient about this, but if I think need to object to the leading nature of the questions in this testimony.
Did you have a conversation with Kathy Wiles and Paul?
Yes, I did.
Tell the court what that conversation was about.
Now, this was at Butch's funeral.
Okay.
I asked Kathy and Paul if they wouldn't mind if they would trade the money I put out on fixing the door for a .22 rifle that was Butch's house. And they both agreed that they would trade me the rifle for the cost.
Objection.
that I had. You talking to me?
No.
To the judge. Objection hearsay, Your Honor.
Armstrong, I did not hear you.
Objection hearsay, Your Honor.
Okay, overrule. Go right ahead.
Go ahead.
Okay, they both agreed to trade me the rifle for the money. And Paul had already taken all the guns home. He agreed to meet me when I called him halfway from his house to Beaumont to give me the rifle. And Kathy agreed to the same terms. So when I called Paul to meet me, he had changed his mind and said he would not give me the rifle.
Your Honor.
He would not pay me my charges for what I spent on repairing the house.
Your Honor, this is speculation and hearsay. Object to the testimony.
Mr. Wilcox, can you tell the court what you spent to repair the front door?
I paid a carpenter friend of mine $300, and I did not charge any labor myself for helping him install the door and repair it.
Okay. And were you willing to forego reimbursement for that, those services in exchange for the .22 rifle?
Yes, I was.
Okay. Now, in addition to the rifle, were there 3 pistols in the .22 rifle taken by Paul?
Yes.
All right. Were there also sums of cash taken by Paul from the home?
Objection, objection leading, Your Honor.
Did Paul tell you that he removed cash from the home?
Yes, he did.
Objection, Your Honor. This is this is hearsay.
Oh.
Your Honor, Paul Hilton and Philip Hilton are parties to the lawsuit.
Yeah, overruled.
I'm sorry.
I said overruled.
Thank you, Your Honor. Okay, I didn't know if the court was waiting for me to respond. Sorry. Okay, the conversation that you had with Paul Hilton about the cash, tell the court what he told you.
The first day he told me that he found close to $5,000 cash. The second day, the very next day, he come back and told me that it was closer to $10,000 in cash after his wife had counted it. And also there was $140 that was in a drawer and it wasn't there anymore.
And the $140, was that the money that you saw or found in Butch's pants pocket?
Kathy told me to take it to get cat food for the cats.
All right. And when you went back after Paul and Philip had been in the house, was the cash there?
No.
Had anybody else accessed the house besides Paul or Philip other than you?
Not until Kathy Wells and Kay and Kay's daughter, or Kathy's daughter come down.
And this was after the funeral, is that correct?
No, they come down one time before the funeral.
Before the funeral. Oh, yes, thank you.
Didn't come down.
Okay,
before.
I'll pass the witness, Your Honor.
Mr. Armstrong, Mr. Waters?
No questions at this time, Your Honor, reserving our right to re-question this witness later on after we've conducted discovery.
The same, Your Honor.
And Kathy.
Okay, Mr. Partain, y'all had requested 2 hours. We're a little bit over that now. And I do have another meeting, but I have a few minutes. If you have another witness.
Your Honor, I have just a few questions for Kathy Wiles, who's present today. And may I proceed, Your Honor?
Ms. Wiles, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
Yes.
Go right ahead.
Right. Okay. Ms. Wiles, state your name for the record, please. Can you state your name for the record, please?
Kathy Wiles.
Okay. Ms. Wiles, your cousin was Butch Caldwell, is that correct?
Yes, sir.
And did you consider that you had a good relationship with Butch?
Yes, I did.
During the time in 2012, did Butch send you copies of the estate planning documents that he had executed with Mr. Quigley?
Yes, sir.
Okay. And Your Honor, if I may share the screen for just a second here. Okay. Let me ask you to look at exhibit number 6. Is that a photograph of Butch and you?
Yes.
Who is the other lady with you there?
She's our aunt.
Okay. And I'm going to ask you to look at exhibit. Let me see here. Okay. I'm sorry. I'm looking for my. Okay. Let's ask you to look at a document that I have pulled up here, proof of death and other facts. This is information. Do you see that document, ma'am?
Yes, I do.
Okay. And you're aware that Butch Caldwell, Joel P. Caldwell, died on April the 30th of 2021. Is that correct?
Yes, sir.
Okay. And he lived in Jefferson County?
Yes, sir.
And the document that you've seen, the July 12, 2012 document that is the conformed copy of the will, you've seen that document, is that correct?
Yes, sir.
Okay. And Butch provided that to you as a part of the information that he was sending to you, is that correct?
Yes, sir.
Let me ask you to look at what I've marked as exhibit number 3. Do you see this document?
Yes, sir.
Okay. This document has, it's an envelope addressed to you, is that correct?
Yes, sir.
And it's, and the date of the envelope is, can you see that? I can't.
November the 19th, 2012.
Okay. And this is a copy of the envelope that Butch sent to you, is that correct?
Yes, sir.
All right. And what was in this envelope?
It was the will, a power of attorney, and the medical power of attorney.
Okay. All right. And those are the documents. And was there also a letter from, that included a letter from Mr. Quigley?
Yes, sir.
Okay. Your Honor, at this time, I would offer Exhibit 3, the envelope.
Any objections?
Our running objection, Your Honor, and I would object. I think there's been insufficient authentication for this document, Your Honor.
Any other objections?
I'll join in that, Your Honor.
Okay, overruled and be admitted.
Okay. Kathy, after Butch's death, well, let me back up just a second. Prior to Butch's death, you knew that he was having some health difficulties. Is that correct?
Yes, sir, I did.
How frequently did you talk with Butch during the week?
Probably toward the end when he was very sick, I would say about every day.
And were you aware that he was taken to Baptist Hospital on April the 19th?
Yes, sir, I was.
And did Baptist Hospital contact you about making decisions with regard to Butch's health care?
Yes, sir, they did.
Okay. So was it your understanding that Baptist Hospital had the medical power of attorney?
Yes, sir.
Okay. To your knowledge, did Butch ever change anything with his power of attorney or the medical power of attorney?
Not to my knowledge.
Okay. The Edward Jones account that we looked at earlier with Ms. Lombardo, you were the sole beneficiary of that account. Is that correct?
Yes, sir.
Okay. Let me ask you to look at one other document here, and it's Exhibit 16. Do you have that? Can you see that in front of you now?
Yeah, well, I'm getting, yes, sir.
Okay. This it's a contract for Butch Caldwell's home repair. Is that correct?
Yes, sir.
And did you find this document in Butch's personal papers?
Yes.
Okay. And the personal papers included this contract that's dated December 26, 2018. Is that correct?
Yes.
Your Honor, at this time, I would offer Wiles applicant Exhibit 16.
Any objection?
Our running objection, Your Honor, and also insufficient authentication.
Yeah, it looks like hearsay. Can you go up a little bit? The next page, is it signed or
yeah.
Is that it? Yeah, I just object as an unauthenticated hearsay as well.
Ms. Wiles, did you determine that these particular amounts were?
I'm sorry, did we get a ruling on the objections? If we did, I didn't.
I'm still looking at it.
Sorry, Your Honor.
Yeah, sustain.
All right, Ms. Wiles, do you know that Mr. Butch Caldwell's home sustained damage during Hurricane Harvey?
Yes, sir.
Okay. And with regard to the damage, do you know when it was repaired?
I'm not sure as far as the dates, but it was a while before it was repaired.
Okay.
Because he stayed, he was not living there for a while.
All right. Thank you. Okay, Your Honor, with the court's time constraints, those are all the questions that I have for her right now. Thank you.
Any questions, Mr. Armstrong or Mr. Waters?
Not at this time. We'll reserve our right to question this witness later on after discovery.
Your Honor, I do just have a very few questions, if I may.
Who was that was speaking?
This is Mark Waters. I do have just a very few questions. Again, I would still like to reserve the right to ask more questions later. Again, it'll just be very few.
Go right ahead.
Good afternoon. Ms. Wiles, who is Marla Hilton Spencer? Is that a cousin?
I think is it a cousin or might be a sister to Uncle Mo.
Is that a relation to Joel Caldwell?
Yeah, I'm really, no, it wouldn't be, yeah, it would be Uncle Mo if it's Marla Hilton, because that's their last name.
Yeah, what was it? Joel Caldwell's cousin?
I'm really not sure.
And do you know if Marla Hilton had children?
No,
Just asking, do you know, or Wade? Wade, is Wade Hilton sound familiar to you?
no.
Okay, that's all you are. Thank you.
Your Honor, one follow-up question, and my co-counsel, Mr. Celeste, reminded me. Ms. Wiles, during any of the conversations after July of 2012, did Joel Caldwell or Butch Caldwell ever tell you that he had changed or revoked his will?
No, sir.
To your knowledge, was the will ever changed or revoked by Mr. Caldwell prior to his death on April the 30th of 2021?
Objection calls for speculation and a legal conclusion.
To your knowledge, was it ever changed or revoked?
Not to my knowledge, sir.
Overruled.
That's all that I have, Your Honor. Thank you.
Your Honor, I'm sorry. We ran out of chairs here, so I'm without a chair. I guess we would just ask that despite the requests from opposing counsel that they have additional time to conduct discovery, as Mr. Partain pointed out earlier, they have time to assert a contest to the will. We believe that we've met our burden of proof with getting the will admitted to probate. I understand you may not rule on it today, but we do ask that the will be admitted to probate and that Ms. Wild be appointed independent executrix of the estate. And that's all.
Well, I think that I want to allow the other parties an opportunity to be heard. I want there to be full and fair disclosure. And I don't know whether Mr. Partain, it might be a potential for one of the parties to file a motion to try to get information from the financial institutions so that we can at least have some information about what probate assets are there and whether or not it's appropriate for the parties to engage in mediation. But I will take these issues under advisement and ask the parties to submit brief statements of your positions with respect to our moving forward and your justifications for that with citations to the estates code. And if I think of anything else after the hearing, I'll make sure and communicate that to council for all parties.
Thank you, Your Honor.
Anything further, gentlemen, Mr. Armstrong or Mr. Waters?
Your Honor, I'd just point out that in our opposition, we asked that discovery be conducted pursuant to level 3. And Your Honor, we just asked for entry of a scheduling order in this case.
No, I'll also take that under advisement. It's just, which is one of the reasons I'd like to find out what kind of probate assets are there. Because it might have a bearing on the ability to get this case resolved one way or another. I don't know. But if the banks are recalcitrant to provide you with information,
Yeah, that's been the problem, Your Honor. We've got, for example, Prudential on a life insurance has threatened to send the money to the state through a sheet instead of either tendering it to the court because we don't have a representative yet. And that, along with For example, the banks are stonewalling us with that. So that's why having, the urgency for going forward with this.
Yeah, and I understand that, but I don't know whether or not a temporary administration would have been a more appropriate vehicle, but I'm willing to read anything you send me. And my most humble apologies to each of you for not having had the opportunity to read everything because of the court's belief that this hearing was not going forward today. I wish I knew who it was that called here and canceled the hearing, but anyway, I will attempt to make up for that by making sure I read every jot and tittle before we meet again.
Thank you, Ron.
All right, thank you, gentlemen, for your time.